Adjournment request, if any, from item number 1 to 5.
Three, no? Three. May I have your lordship leave to mention item 3?
Item
3.
3, yeah.
We have just entered appearance today. We'll file an affidavit, my lord. Your lordship may give us some time.
Yes, what about?
Yeah, Your Lordship, I am the contender number 1 in item number 4. Lordship, I have submitted an affidavit on 8th of May 25, Lordship. It is in the file, Lordship, in the record.
Yes,
If they wants time, Lordship may give short time.
what about the?
In respect to item number 4, Lordship, they have filed affidavit, Lordship. We have received it, Lordship. After going to the contents, Lordship, the affidavit it amounts to again content.
That's altogether different. thing.
Lordship.
You want to file any counter to that or
Also,
not?
we'll go to it and if necessary, we'll file it, Lordship.
Yeah,
If necessary, we'll file it, Lordship.
okay. Item number 3, दोनों के साथ ही बना थे. In contempt case number 1/2025. P.K. Goswami, senior advocate, assisted by so and so, has put an appearance on behalf of the respondent number 1. He takes some time to file counter to the contempt petition. Time paid for is granted. List on when, how much time?
I'll leave it to your lordship, but
No,
you will give us a little time, my lord, so that
just how much time?
6 weeks, subject to your lordship convenience.
Till
6 weeks.
6 weeks, too long, Lordship. Lordship may at
It
least 4 weeks.
is a contempt matter. What is the urgency? I don't know.
This for 6 weeks time. Time paid for is granted. Response also. Time paid for is granted. Like, we can item number same order sheet नहीं करते ना, title अलग लगा. Contempt case number 2/25. Reply to the contempt petition is filed on behalf of the respondent number 1 on 8th of May 2025. Full stop. Then counsel appearing for the advocate general, Mr. So and so, raised some time to go through the contents of the affidavit, reply to the contempt petition filed on behalf of the respondent number 1. He submitted the contents of so and so. He praised liberty for the petitioner to file counter to the affidavit filed on behalf of the to file response to the counter affidavit filed on behalf of the respondent number 1, if necessary. List on so and so. दोनों का date एक ही था.
Lordship, in respect of respondent number, Lordship, on the Lordship, order of the Supreme Court. Lord.
Okay, is to be noticed that the Honorable Supreme Court in SMP number so and so has kept in has ordered for keeping the proceedings against the respondent number 2 in both the petition in abeyance. Full stop. List on so and so. After 6 weeks, का एक date है.
25th June. 25/6.
6 weeks. Which date?
Date has not been, but they have 6 weeks has been given, Lord.
Yeah.
It will be there for tomorrow because let us see what is going on.
Let us see if anything.
Day after tomorrow.
You
then
can
day
very
after
well,
what she may
you
pass.
can very well move an application for that. If you want an early listing, you can move an application for that.
There is no urgency on my side, but
No, subject to the order passed by the Honorable Supreme Court, you can move an
court
application.
has passed an order only in respect of one particular criminal.
That we have already noted.
Yes, therefore, subsequently, Lord, the honorable that this honorable court may proceed with against the other two LS contempt.
Then we are proceeding.
Yeah,
So now, tomorrow the matter is fixed in Supreme Court. So that's why this order may be passed day after tomorrow. Let the matter come up day after tomorrow.
If, subject to the any order passed by the Honorable Supreme Court, if you feel so, you move an application for early listing, we'll list it.
Yes.
List the matter.
Hello. If I respect that a mention is made, we should be informed. Nobody has informed that it will be mentioned. I was waiting for item number 4.
Can very well request that.
Normally, that is the practice. All
So
these
you can
practices
very well
are gone for
request
a
them,
six
sir.
now. These practices are gone for a six now.
But
We
you
are
can very
used
well
to,
request, okay, next time you please inform.
okay, okay.
25th June.
Quickly obliged.
Adjournment request from item number 6 to 15.
In item number 1. Yes, sir.
Adjournment request from item number 6 to 15. From item number 16 to 24. Adjournment request.
64, Milord, there are items 7 to 11.
7 to 11.
11, there,
So what remains in these
Milord,
matters?
that is what I was saying, that the government wanted time to know the position and inform you. I think that is the
That is the last order in the year.
Last order, that is
2023.
my recollection.
But now what remains in these
Milord,
matters?
that is, we should verify because so many teachers are involved. I don't want to give a commitment without consulting them. So government,
Let the number come.
let the number.
Let the number.
Huh. That is it.
Any
Yes,
other
Your
request?
Lordship. Lordship, I beg to mention item number 16, Lordship. Only for the day may be possible, Lordship.
1/6.
Yes, Your Lordship.
Let's see. What is the wrong with the Leonard single judge order?
Lordship.
What is the wrong with the Leonard single judge order? Appointment on the basis of the employment exchange.
Lordship, we have challenged this, in this matter, Lordship, Senior Advocate P.J. Sekia will,
Have you sought permission or consent from the other side?
Lordship, other side, Vikas Prasad, I will inform Lordship. He has the consent, Lordship, I will inform Lord.
You have already sought the consent.
Yes, Your Lordship.
Okay. Learned consent for the petitioner. Appellant pays for an adjournment. It is submitted that the consent of the other side is already obtained. This in the month of September.
Highly obliged.
Your Lordship, this tea garden auction is on this 15th of this May. If the this thing Lordship would like release this matter tomorrow because the
Matter.
that is
the
that is related to the auction of tea garden property.
Make a request with the registry. Registry will consider.
That is very urgent.
Urgent, that's why only show your urgency to the registry, they will take care of it.
The auction is on 15th.
Whatever it is.
Daily list for orders item 1 and 2.
Yeah, please, your lordship. Lordship, regarding PIN number 6, that is item number 1, your lordship, I pray adjournment for the day because Mr. Aryan Das is some health problem today, your lordship. He's defending the case on behalf of Social Justice.
On behalf of?
On behalf of Social Justice Department, your lordship, Aryan Das, he is not
But
well.
in the last occasion, some affidavit was filed and
Yes,
wrong
sir, that
documents were
is-
submitted.
Yes, that's
What happened
already
to that?
submitted, your lordship.
You
That they got it corrected and they supplied me a copy pertaining to that
you want
PIL
to
six.
file any counter to that?
Yes, we have also filed.
When? It is not on record.
That may be brought on record, your lord. It was filed. Eleven.
11?
Filing to date of receipt. It was filed on 23rd.
23rd, yes, it is on. Okay, will the pleadings are complete, we'll list for
Yes,
hearing.
yes, we can,
The pleadings,
this matter may be
is,
fixed for
uh,
hearing.
the
However,
PIL petitions are complete. List this PIL petition for hearing. When?
on Friday,
Not Friday. On 10th of June.
your lordship, there is another more, PIL 2 was there. And the other side was about to clarify their
Both the-
stand.
Both the petitions are listed for this hearing.
Okay, Your Lordship.
PL two, we have filed our affidavit. We have already filed it.
Report too.
The affidavit we have filed.
Okay, that's why only I've said the meetings are complete.
PL two affidavit का सगळ्या मी फोन आया था
21/4.
21/4.
अब लगा.
Item number 5.
Obliged, Your Lordship.
May it please your lordship.
Well, not precisely on the same point, there is a division bench judgment of our High Court, my lord, which I have already placed the other day. Now, my lord, one very pertinent aspect in this case is, if your lordships would kindly come to this Megha Chandra's case, my lord, which we are relying heavily. If your lordships would kindly have this 2025 SCC 689.
Yes.
2025 SCC 689. For hearing this case, the date was 1/1/18 and ours is 3/18. Like every second person. But if you speaking in the absence of the rules, at times favorably in some way it is not otherwise income. We make that argument. Yesterday. Now, how many clients are there now between Zambia and two? The integration. And I am very not regular. The Indigo is regular, no? It's a moving or a small item.
That's
No, I have gone through the judgment of this one, I respect the judgment that they passed by this court. But if your lordship looks into the facts of the case, in our case, I like to just take some few time before your lordship to show the judgment, how the judgment was dealt by the learned single judge. And it has been discussed. Megachandra has been overruled also, that has been also spelled out by the judge. So the learned single judge was very much conscious about the judgment of Megachandra. So I just want to just few the judgment, how it was delivered, and few points I just want to bring notice to this honorable court.
you please first come to
Yes,
this improved order error number. This 31.
now my lord is taking up 143, 143, recapitulation, there are two recapitulations.
Yeah.
140. Your lordship is,
I think so, in both the judgment is common,
no, separate.
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 31.
Yes, page, my lord,
But in the later case, my lord, this judgment has
they
been followed.
relied, yes. Page 31 of the, my lord,
Of the improved
single judge judgment.
single judge judgment.
Yeah.
In this petition number, this 127.
I'm on, yes, 30, 31.
Yeah.
31, okay. Okay, 31, yes. Para 31. Lordship is talking about para 31. May I read this para? In the present case as well, that the MCS rule 2002 and even in the subsequent MCS rule 2012, there is a fixed proportion quota meant for direct recruitment promotees to make their entry into a junior grade of the MCS. The claim for interspacing between direct recruits and promotees in the seniority list is on the basis of a judgment rendered in N. Paramar and others circulated through OM dated 4/3/2014. Apparently, the case of Marbin, County and others, and the case of M. Subbareddy were not taken into account as was observed in Hariharan and others. So, right, when Hariharan, my lord, two judges, they say that this was not taken into consideration when Megachandra was deciding. Ordinarily, seniority cannot be claimed from the date when the incumbent is not yet born in the cadre. But in the present case, there is no dispute with the fact that the MCS rule of 2002 and even in the subsequent MCS rule of 2012 provide the quota for entry into a junior grade of the MCS by direct recruit and promotees and criteria for fixation of inter-se seniority, holding the field insofar as the present case is concerned was the OM dated 4/3/2014. A reading of the OM as a whole and the case of N. Paramar and others in the considered view of this court leave no room for doubt that irrespective of dissimilarity in the dates of appointment between direct recruit and inductees, their inter-se seniority will have to be fixed by interspacing them in terms of quota allotted to both the source by.
Mr. Das, in the view of that this judgment is already overruled and at present the situation is the same. Learned single judge can apply that this judgment.
No, I kindly see. That's why I just want to read few of the paragraph, how it is dealt insofar as overrule is concerned. Although the case, my lord, I'll just draw your lordship attention to paragraph.
There are judgments.
My lord, kindly see 25. Answer to say 25, paragraph 25.
Yes.
Proceeding to the contention of the petition, my lord, before that, 2010, the facts is important. I'll just tell the fact.
The process for
Yes,
direct
it was on
recruitee and the
Right.
this promotee
9/10,
were started,
2010.
was started.
9/8/2010.
Was started simultaneously, but later on, for whatever account, this selection of the promotee was not completed. Yes. Along with that direct recruit.
Correct, right.
And they were provided appointment prior to this promote,
2012,
2012.
yes.
And ultimately you were promoted in the year 2014,
Yeah, 15.
15
15,
by the indulgence of the single
Order.
judge order.
order, yes. Yes,
That was the.
because there were,
Now the question is whether your seniority can be reckoned from 2012 or 2015. The learned single judge has said that since the vacancy or the advertisement were issued in the year 2012 itself, when they thought your seniority reckoned from 2012.
yes,
And you were supposed to interspace between the direct recruitees and
Correct.
so and so. Based on this NR Parmar judgment.
yes.
Now, NR Parmar judgment, sir, as on today, it is overruled.
No, my lord,
Though it is
Yes.
to the larger.
my lord, that larger bench, when it is overruled and it has been referred to a larger bench, whatever judgment that was prevailing earlier, that will prevail. That is my humble submission that now there is a judgment of
This overrule. This
Subba
NR
Reddy.
Parmar judgment.
No,
won't prevail.
not N. Parama, my lord. Three judges, Subba Reddy. Subba Reddy is three judges and Meghna is also, Megha is three judges. So the learned single judge, with great respect, my lord, learned single judge said that N. Paramarama is overruled, but whatever the process it was initiated prior to the judgment passed by Megha Chandra.
Yes.
If you see para 26 of the judgment, my lord, I just read that para 26. May I read, my lord?
Yes.
25. 26. May I read 25?
Yes.
Proceeding to the contention of petitioner, they should be interspaced with the private response numbers 4 to 12 in the interest and seniority list of the MCS junior grade. The basis for making such a claim is mainly in terms of the instruction on fixation of interest and seniority of direct recruit and promotees circulated by OM dated 4/3/2014. The OM is based on the decision of the apex court rendered in NR Paramar and others. According to apex court, the date of joining would not be a relevant factor for determining seniority. It would suffice if action has been initiated within the recruitment year in which the vacancy has become available. Now this is important. Delay in administrative action cannot deprive an individual of his due seniority. Now, my lord, 26. At this stage, it may be noted that Mizoram Civil Service Rule 2000 MCS rule, as amended from time to time, does not provide as to how the seniority should be fixed among the members of the service. All that Rule 23 says is that seniority is to be fixed in accordance with orders and instruction in force before the commencement of the rule and after the commencement of the rule in accordance with such determination of seniority regulation as may be made by the government. OM dated 4/3/2014 was therefore issued in terms of judgment rendered in NR Paramar. However, the said decision has been subsequently been overruled in K. Megachandra Singh and others by a three judges bench of the same court. It was held that the seniority cannot be claimed from the date when the incumbent is yet to be born in the cadre. It was also observed that the decision will not affect the interstate seniority already based on NR Paramar, and that decision will apply prospectively of K. Megachandra Singh, which was decided on 19/11/2019, while the instant petitioner was inducted in the junior grade of MCA on 15/1/2015.
Ultimately, sir, the seniority was granted in the year 2018.
I'm sorry.
18, ultimately the
No,
seniority.
but that is a
the
list.
senior gradation list was issued
But, my
and
lord-
the gradation list was issued, objections were invited. After receiving the objection, it was settled in the year 2018.
Well, maybe, yes.
Now, sir, to unsettle that on the basis of NR Parmar, that is questionable.
No, my lord, that is what. Well, I have seen, your judgment is right in passing that in context of that case. I fully agree. My lord, N. Paramar.
That, sir, that judgment,
yeah,
in
yes.
the Delhi High Court.
Yeah, I have seen. No, your lordship judgment, I have seen that.
Yes.
I have read. My lord, here also learning single as an overrule, but decision with all this process has initiated earlier. But due to fault, something has happened to the government. Then there is a judgment of the court in 2013, which was challenged by two of the inductees. In 2013, 1/10/27 of 2013. In that, their case was that how they can be left because the process has already initiated in 2010. Now the learned single judge in 2013, he said that yes, as it has been left, they could not have been left because there is what it has been, the government has told it. Government subsequently it has been cancelled. There may be some reason, hundred of reasons there may be.
Maybe that has already been annulled.
Then
by the
this
learned single.
annulled. So the learned single judge in 2013 says when it has been annulled, it has to be there. Inductive case has to be considered in basis of 2002 rules. Now 2002 amended rule, 2002 rule is 66% and 33%. So if it is that, then it goes back to 2010. That is my respectful submission before your lordship. 2010, where my lord, the government says, then 10% will be a direct recruiting and 5% will be inductive. So that vacancy always remain. You cannot break them down that vacancy. My lord, my respectful submission is that you cannot break down that vacancy, 5 vacancy cannot be break down. That's my respectful submission before your lordship. That has arose in 2010 itself due to some reason. But when the learned single judge has passed the order and set aside both this, one is the stall, where they stall and subsequently cancel, it will be, now I don't have a case if you go by 2012 rule, because 80%, 20%. My lord, that is a position. But when you go back to 2002 rules, then the position as on date 2010, 5 vacancy remains. 5 vacancy. Can you say that 5 vacancy will break down that 5 vacancy and your seniority, interspacing will be on 2002? That's my case, my lord.
কিন্তু সুপ্রিম কোর্টে জাজমেন্ট রেফার করা নাই নাই নাই
Consider all this, sir.
That's why.
We'll admit
yes.
the additions and we'll consider them.
But because they should, my lord, is
Till
status
then,
quo.
status quo should be-
Yes,
Status-
yes.
These two. Reluctance of the- By the appellants being agreed with the judgment and order passed by the learned single judge on 25th of March 2020. Writ petitions number 127/2019 and
Yes, my lord, 2019. And the other one is 144, sorry, 95 of 2019.
95 of
2019.
2019.
Yes,
95 of 2019.
second,
Date of judgment is the same,
same.
19. Full stop. The learned single judge by the improved order directed the respondent state to The limit signatures by the impugned order while setting aside the inter se seniority list issued on 4/9/2015 and 21/6/2018 in relation to the employees involved in this litigation and as directed to refix the inter se seniority of the incumbents by interspacing the petition of the writ petitions with the appellants. Stop. The learned single judge has relied upon the decision of the Honorable Supreme Court rendered in N.R. Parmar and others versus
Union of India, Miller.
versus Union of
Actually, Union of India versus NR Parma.
Union of India versus N.R.
NR.
Parmar reported in 2012-13 SCC 340. Stop. The contention of the appellant is to the is that the judgment passed by the Honorable Supreme Court in N.R. Parmar and other Supra is already overruled by a three judges bench of the Honorable Supreme Court rendered in K. Mega Chandra Singh and others reported in
2025 SCC 689.
2025 SCC 689. Stop. Learned counsel appearing for the respondents. Contesting respondents are supporting the impugned judgment and has argued that the learned single judge has not committed any illegality in setting aside the
Seniority.
notifications dated 4/9/2015 and 21/6/2018 and has rightly directed the respondent state to refix the inter se seniority of the writ petitioners by interspacing them with the appellants. It is contended that since the recruitment process for inducting the private respondents as promotees was started in the year 2012 itself. Their 2010 itself, their seniority is to be reckoned from that date only as per the law, as per the settled law. Having heard the learned counsel for the parties and after going through the material available on records, we are of the view that matter requires consideration and admit who is for the state. You are appearing. So and so is appearing on behalf of the respondent state. Respondent number one, Mr. Didas, let's say a senior counsel, assisted by so and so is appearing on behalf of the private respondent in both the writ petitions. In both the writ petitions. We can a respondent number appearing for respondent state in both the writ appeals. And Mr. Son Didas is appearing on behalf of private respondents and so hence no need to issue formal notice. List this matter for list these writ appeals for hearing in the month of September.
Miller.
In the month of September 2025. In the meantime, status quo as is status quo in respect of the seniority of the appellants as well as the private respondents be maintained till final disposal of these writ appeals.
Can it be before September, if it is possible? I don't know how, before September, come out. If it is possible. If this,
Possible, it is
or
possible.
somewhere in August,
August.
July.
August.
Yes. Deeply obvious.
For hearing, item 7 to 12.
May I please?
Yes, who is appearing for the state? Council,
I'm appealing.
Mr. Majumdar on 1/8/2023
Yes, madam.
is stated before this court that certain new developments have taken place which are required to be brought on record for consideration of this court. What happened? What about those new?
Madam, in that regard, madam, I am seeking 1 week time, madam. In fact, today, Mr. Mosundar,
You placed everything on record, the new developments and something.
that is not on record, I guess, madam.
लिखिए।
My lord, I am appearing in item number oh, 11.
What about the note? कर लेना अपन का।
Lord, I was only trying to point out one thing, my lord.
Yeah.
In item number 11, our prayer was for regularization.
Yeah.
Now, by virtue of the subsequent action, we have been given everything other than pension. So,
Pension
pension, my lord. There is a specific clause
regularization from which date?
from, of course, that is there, my lord,
From which date?
from the date of the order.
Which date? The date of order is?
1 second, my lord. I'm just giving.
That is also now under challenge, Milord.
Is there another?
That is
petition?
pending.
I think so. Tomorrow those petitions are listed.
Yes,
Uh,
those are things.
I don't know.
My
but
lord,
I
this
think
order
that
was
moved
passed on
on very
1st of
soon.
July 2020.
2020.
हाँ.
As per the law, sir, you are not entitled for that. 2005 से पहले का appointment, we can't treat your appointment prior to 2005. And recruitment, in fact, no such recruitment was initiated.
Well, what I'm saying
on
is-
the date of 2020.
No, well, I'm not making any argument on the legality of what has been done. What I'm trying to submit is
No, then pensionary benefit, you mean to say old pension or new pension?
old pension, my lord.
Old pension.
Pension दिया ने.
No,
Well,
what I'm saying is, no, what I'm saying.
No. Let us be clear. The new rule, they have regularized some of these contractual employees, but with conditions, one of them being that you will not get pension.
Yes.
You will not get pension.
Pension.
That is, we have challenged, because
Ah.
at least I have moved 1 or 2 petitions.
Kindly,
That is
kindly.
pending. So that is a different thing.
So what I'm saying is, my lord, by this order, we have been taken off guard. Now, perhaps we'll have to amend our
In
petition.
your petition now, here the learned single judge refused regularization of your services.
Yes.
But ultimately, now your services
on
have
the
been
item number
regularized.
11.
Oh, 11.
Now your services have been regularized.
Yes.
And
We have been,
another thing regarding this pension and all, that is altogether a separate thing.
yes.
So why this petition be kept pending, sir?
Or then lordship should give us liberty to hesitate in an appropriate, yes, that can be done. That is my case is concerned, that can be done. my lord. Kindly see, my lord, clause number 5, no pensionary benefit will be delivered to this teacher.
That's, okay. That's another thing, that is a
Yes.
separate
Yes,
cause
that-
of.
So we
That
may be
is-
given liberty to hesitate in an appropriate proceedings. That way, lordships can close my case.
In item number 11,
Item number 1610 of 2018 WPC.
that is writ petition.
Yes, my lord, 1610 of
But
2018.
writ petition seeking regularization.
Yes.
Okay. ये देना जरा 1610. Mr. Goswami, your case is this
Item 7,
Seven is.
it's a state appeal against the judgment of the learned single judge,
Yes,
where he held that so far as that qualification is concerned,
that is not required.
that is not required for the higher stage, that is secondary stage. Even that is the 93 in the Central Government Act.
Yes, that's
So here, the rule was amended, Rule 12 of the earlier, that act and the rule also has gone, where they said that that will be needed even for the middle class as well as the higher secondary class.
after passing of this judgment or prior to that.
No, that is,
That
we
is not
challenge.
challenge.
We challenge and the
Allowed that.
learned single
Yes.
judge said that is
Now, what is the, at present, what is the status of these respondents?
respondents will not, I understand they have been regularized.
Regularized.
But with those modifications, and that is being selling. So it is a very much of a mixture. So I can't,
Now, remains in these petitions.
that is, the
Yes,
state should
Mr.
tell your lordship.
Remains in these petitions. Once you have regularized their services,
Yes.
then what remains in these petitions?
Item 7,
So far as regarding this pensionary benefits and other
Ah.
things are concerned, they are already agitating, they are already
That is
agitating
pending.
somewhere in another litigation. What remains in these petitions?
Actually, I did not have the opportunity.
You go through the matter, we'll take it after some time. What remains there? This item number 7, 8 and 9 and 10.
8 is slightly different.
Well, difference that is metri something.
Mother's case.
That can't be given.
No, no, no.
The learned
That
single
that is,
judge was looking at
I'll give your lordship a few facts.
Sir, in fact, there is no recruitment process, no appointment, nothing is there.
No, no.
The learned single judge has taken care of everything.
I'll just give me 2 minutes.
See, we'll give you a full
Ah,
time, sir. We'll not-
Because that is a case,
Okay,
my lord,
uh,
I have
just
been
a minute.
fighting for a long time.
No, no, just a minute, we'll hear you.
Ah.
Item number 7 and 8, 7. And this item number 9 and 10. What do you want to say? After some time, we are taking it after some time. You come prepared. In item number 11, you just, this
Mother.
writ petition is filed by.
11 to
Essentially challenging the OM dated 7/2016 issued by the Principal Secretary of Government of Assam Education Department, whereby it was made mandatory for the candidates, including for the petitioners to appear and pass the test conducted by the government for the post of graduate teacher in provincialized higher secondary / high school. The respondents, the petitioners have also prayed for a regularization of their services. It is informed that during the pendency of this writ appeal, writ petition, the government has already regularized the services of the petitioners wide notification dated 1st of July 2020. However, a condition is imposed that no pensionary benefits will be delivered to these teachers. Full stop. Learned concept of the petitioner has frankly submitted that since the services of the petitioners have already been regularized, not much is required for adjudication in this writ petition. However, so far as regarding the claim of the petitioners regarding the pensionary benefits, the liberty be granted to the petitioners to agitate the same before the appropriate forum in appropriate proceeding. Full stop. Learned counsel for the respondent state has no objection if such liberty is granted. In such circumstances, this writ petition is disposed of with liberty to the petitioners to agitate their grievances, if any, in accordance with law by availing appropriate remedy before the appropriate forum.
Deep privilege.
11, no?
11.
We'll take these matters after some time. Let him complete his instructions.
Day after tomorrow, my lord, I'll have a consultation with the department also on the present status. Day after tomorrow, my lord, Papaji.
If anything remains in these matter, then argue, otherwise, and what about this item number 10?
10 to
Mr.
8.
PK,
The rule has been repealed.
Rule was challenged, my lord, prescribing TET for post, the
now
secondary.
your services have been regularized.
They have been regularized. Keep that question open if they ever take
Let
it.
me, the same order,
Ah.
will pass the same order.
No, this question was not there in the case just delivered by your lordship. This is a case where we challenge the validity of that provision itself.
But sir, now if you're.
Now, and that act has gone, rule has gone, so your lordships, they may again bring in tax, I don't know, therefore, your lordship, that
Then
question
it-
should be
it-
kept open. Kept open, that will be.
Same order
enough.
करते हैं, अभी इसमें
The question relating to validity of that is kept open,
This
that's all.
item number 10 में लिखना. This writ petition is filed by the petitioner being agreed with the action of the state government, whereby it has mandated for the petitioners to clear the TET examination for the purpose of appointment on the post of
9 to 9 to tomorrow to appeal against Ujjwal Bhuya.
7-9 দুইটা
9 to Ujjwal Bhuya order to interim order against. Mothers to no corner. The mothers of the student, we have offered that to me, a ticket open the ticket.
the TET examination for the purpose of appointment on the post of which post you are seeking appointment, sir?
Teacher,
High second,
Hi-
assistant teacher,
assistant teacher,
secondary school.
Assistant teachers.
yes.
Assistant teachers in the government
Secondary
of
schools.
Assam. Full stop. It is noticed that the learned counsel for the petitioner has submitted that since the rules by which the above referred provision was made has already been amended and the services of the petitioners have already
Repeal, not amended, repeal and new rules have come. That's why.
has already been repealed and new rules have been introduced.
Which is under.
And the services of the, and in the meantime, the services of the petitioners have also been regularized. Not much is required to be adjudicated in this writ petition. However, so far as regarding the remaining grievances of the petitioners, such as pensionary benefit,
Pension that is pending.
pensionary benefits are concerned, the petitioners have already
Benefit around the amount of 2010 or
approached
senior.
this, approach the writ court
Benefit
for
other.
Pension and other claims which are being agitated.
pension and pensionary benefits and other claims, the petitioners have already approached this court and their claim is under consideration.
Under consideration.
Learned counsel has therefore submitted that this writ petition may be disposed of in above terms. In view of the above, so the learned counsel for the respondent has no objection if the writ petition is disposed of in above terms. In such circumstances, this writ petition is disposed of.
With liberty, your lordship can have them.
Liberty, when you already said, already filed.
If this issue again.
disposed of. However, the disposal of this writ petition will not affect the merits of the case, merits of the case which has been filed by the petitioners and pending consideration regarding the regarding the benefits. This then number now, Mr. You seek your instruction in 7, 8, and 9. 12, what about 12? Mr. D. Sharma. 12 देना जरा.
Yes.
Same? Same as Mr. Chaudhary. Huh?
They have done the regularization without mentioning.
So the same order has passed in the case of the Mr. Goswami or Mr. Chaudhary?
Chaudhary sir.
वो जो first में जो किया item number 10 में जो 11 sorry item number 11 में जो order किया था वो इनके item number 12 the order which we have passed in item number 11 should be repeated in item number 12 and 10 का भी हमने जो आपको अलग लिखाया था understand?
They need to go to validity of that in secondary stage.
Yes, next. After some time. 7, 8, and 9, after some time you complete your. Go through it. Nothing much is required to be.
Well, so far as that 8 is concerned, that is slightly different. It relates to the mothers. There I am requesting him, they have taken time twice or so. What we have offered now, I'll just give an idea of these ladies because there are a big number of mothers. They are called mothers. Milord, the education development in Assam, your lordship will have to imagine a village where there is no school. So some of the elders gather together and felt the need that we should have a school. That is how, Milord, somebody has given his land, somebody has given bamboo, somebody given others, and a school was established, primary school, for the purpose of educating the young boys and girls at the nascent stage. But who is going to keep the school, lock the school, open the school and clean the school? There, these ladies were inducted. They are called mothers. So your lordships can imagine the young kids who first go to the school with they having taken crying and all that, my lord. And there is this lady waiting to welcome them and manage everything within the school hours. So that is what they were doing, and they were given a sum which ultimately, until today, it is 1,000 per month. So they have moved, and we tried to take the case and pray for regularization of their service. Single judge, landed judge, single judge saw the human side of the story, but he said you can't get regularization. So we are on appeal. So in appeal, I particularly took their consent because your lordships, all courts, below Supreme Court and other after that judgment, Lord, they are saying that you give the minimum of the scale and this, all that. So we said that we are not insisting on regularization. You give us what you have given in that other cases following that judgment of Supreme
Sir,
Court.
you are seeking minimum pay scale against which post?
Because,
Equivalent to
no,
each post.
we are not even saying minimum scale because the statutory rule contains a clause about their class and there is a scale for them. But all that we were claiming is that 1,000 is a very paltry sum nowadays. So you consider our case and give us the scale. All casuals have been given in Panchayat and others. You give us that benefit. Whichever you have given to others.
That is, we will kept it open for
And
you.
they
We'll
wanted.
keep it open for you to move a representation and.
No, we have done it and they took time to inform your lordship what the government is going to do. They have not taken as time as yet. Let him take time and let it come, because I am very concerned about these
Okay,
ladies.
fine. I will take after some time, Mr. Majumdar. In
Or-
between, you complete your instructions.
No. But
Take up the-
I think he may not be in a position to give if he is not being instructed. Because it's a huge number of about 4,000 people. So I think you let him take a reasonable time and give the instruction.
Let him-
Already he has
Let
taken.
him, we'll take after some time.
Okay, as your
What
lordship.
about this 7 and 9? You complete your instruction.
What is the number?
Yes.
That is 8. Item, mother's
Item
case is
number
8. 8.
We are asking to complete his instruction in respect of 7 and 9.
Okay. 8, your lordships can give also that
We'll give,
opportunity.
sir. Let the number come
Oh,
for some time.
For hearing, item 13.
May it please your lordship. Lordship, Mr. D. Seki appears in this matter, lordship. He's on legs in another court in a parted matter, lordship. Lordship, I pray that the matter may be passed over for the day, lordship.
Okay. Then the council appearing for Mr. D. Seke has submitted that he is busy in some other court. Let's stop the whole week.
Item 14 and 15.
I'm being led by Mr. K. Chaudhary, madam, learned senior advocate. He's on legs, madam. After some time, madam. Kindly, madam.
It's covered by that Kerala judgment and nothing else in this. Okay, after some.
My senior will address, my lord.
After some.
Item 17 and 18.
Lordship, I'm appearing in item number 18. My matter has not been admitted yet. It has been tagged along with item number 17, madam.
Malad, this matter may be admitted and take up in another date, Malad, along with item number 7.
Okay, an empty law, no?
Similar issue.
আমি কাম করে আছি কাম করে আছি পুরোনো নন পেশন In my case, your lordship,
That's the match. Yes.
diploma and agency. So they don't need it. No, diploma. Diploma. No, no, I'm kidding. So, it shouldn't change.
So you are for the respondent.
Yes, ma'am. Stay.
Stay. This ultimately the P. Shushila judgment was revisited, in fact, or considered by the three judges bench of Honorable Supreme Court in University of Kerala.
Yes.
The observations are, seems to, you have to deal with it. Because there the Honorable Supreme Court has said that prior to 2010 regulation, whatever the MPhil degree or whatever they obtain, supposed to be taken into consideration.
But it is not in lieu of Malad net slate.
Yeah,
It is not in lieu of Malad net slate, Malad.
that's what the, in the, this three judges bench has taken into consideration in University of Kerala.
Yes, ma'am.
They have also considered this P. Shushila
Yes,
and explained it. That seems to be, you have to give answer regarding. You are aware of this judgment?
Please, Madam.
University of Kerala and others versus Madeline J.
Merlin Jain, AR 2022, SC.
2022 9 SCC 389.
Yes.
I'll take Malad. I'll take from my
Both right. Okay. Okay, common order. The writ appeal number 417/2024 has not been admitted till so far. Over taking into consideration the fact that the point in issue involved in this writ petition is similar to the point involved in writ appeal number 138/2019, which is already admitted. We deem it appropriate to admit this. Admit writ appeal number 417/2024. Admit no need to issue formal notices. Parties are already represented. List these writ appeals for hearing in the month of August.
Lordship, principal, they have not entered appearance yet. In the writ petition, they filed an affidavit. But the principal of the college and the governing body, they have not entered appearance.
They are supporting your case.
May they support? Lordship, may I pray a post be kept vacant, my lord? Post of vacancy.
Will hear you.
Lordship, obliged. Grievance petition.
Item 19.
Okay, so Lordship, this matter relates to rental compensation, Lordship.
Joint inspection report.
Yes,
We
Lordship.
have gone through it. Your representative was very much there.
Lordship.
Your representative was very much there. How can you deny this now?
No, I would just like to make the point out here, Lordship. Now, admittedly, Lordship, the land which admittedly, Lordship, the land which was under the occupation of the army was 34.708 acres. And out of which 6.991 was private land, for which we are required to pay the rental compensation. Our case is that we have paid the rental compensation for 6.991 acres of land. Now, the case of the private respondents is, although the land is within the blue ink area, land is within the blue ink area, but it is outside this 6.991. Now, as a corollary, what would happen is, apart from the land, which is 6.991, 6.991 is apparently private land, and the rest of the land is government land. If these people, the petitioners, are not within this 6.991, the rest of the land is government land.
You just go through the impugned judgment.
Lordship,
What is the directions? What are the directions?
Lordship will come to paragraph 6 and 7. Your Lordship will find at page 51. The assessment of rental charges for occupation of the land of the petitioners by the armed forces was assessed by the respondent number 6 for 3 periods, that is April 66 to 31/8/1986, January 1987 to August 2008. This is the period which they are claiming, and September 2008 to June 2011. Insofar as the assessment of the first and the last period is concerned, the same is already satisfied by the Ministry of Home and the state government respectively. For the second period of occupation under the Ministry of Defense, the amount assessed was rupees 47,50,350.
So it is 3 periods, 66 to 86, 87 to 2008, and
2008 to 2012. It is only the
first
middle
and the last period
are satisfied.
January 1987 to August
August
2008.
2008. Yes, yes. It is for this period that the petitioners have made their claim along with interest for delayed payment. It is the contention of the respondent numbers 1 and 2 that they have paid rental compensation for the area of land covered by the blueprint sketch map, covering an area of 6.991, which I just submitted before your Lordship. However, the joint verification conducted on 15/11/2011 came to the finding that the land of the petitioners actually fell within the areas covered by the blueprint sketch map. And if such is the case, it appears that the joint verification of the board proceedings of 1992 to 1993 appears to have excluded the land of the petitioners by considering their land to be a government free land. Yes.
Now come.
Since it is found that the land of the petitioners are within the blueprint area after spot verification was conducted on 15/11/2011, the Ministry of Defense would only be liable to pay rental compensation to the petitioner as was assessed by the respondent 6 and communicated to the state government in the revenue department on 23/8/2012. Now, on one hand, it says it is within the blueprint area, which I do not deny, Lordship. It may be within the blueprint area.
So earlier, you left your land, treating it as a government land, but
No, it's not for me.
whatever it maybe it's for not for me or whatever the authority, they have treated it as a government land. But later on, it was found in the joint verification that it is not the government land, it is the land of the petitioner. And in fact, we remember
Yes.
in one of the area you said that this joint verification report was prepared behind our back. That was your argument. That's why only we asked them to produce the original, this joint inspection report or to copy of the joint inspection report, which says that your officers were very much there.
No.
How can we deny this, sir, now?
I would like to show your Lordship another document, like when, suppose Lordship, I am in occupation of the land. I am in occupation of the land.
You're in occupation
When-
of the land. Now the question is whether the land
No.
belongs to government or these persons.
So when was the land certificate, settlement certificate issued to the petitioners? If I may take your Lordship to my additional affidavit, which was filed on in in my additional affidavit bringing on record, Lordship, the writ petition. In the writ petition, Lordship will see, I filed by way of additional affidavit. Your Lordship will find at page 23 of the additional affidavit. When was the land settlement certificate issued in
Paper book page.
uh, I've not made the running pages, Lordship, but it was been filed.
Can we find it out?
Uh, It has been filed in March 2021, Lordship. If I may take it out for Lordship.
How will we find from all this, sir? If there is no pagination?
I think this is 199.
What do you want to point out?
I wanted to point out, Lordship, that the certificate as regards the land was issued only in 2004 in respect of the petitioners.
This was not even your argument before the learned single judge.
Lordship, this was a material which was attached to the writ petition.
Sir, whatever it may be, if you attach many number of documents and if you're not insisting, how the learned single judge will go into all this? So the joint verification report, the learned single judge has simply passed an order on the basis of the joint verification report. Now it is at page 308. In the affidavit, or whatever it may be, the joint verification report is submitted here. The team of the officers inspected the petitioners and visited the land in question. The representative of the army authorities produced the blueprint of the land occupied by them in the bridge area survey, prepared and signed by the joint verification team consisting of Army, DO, DC as well and ISOL and Land Revenue Settlement ISOL representative on so and so, which was handed over to the government of Mizoram at the time of the hearing in September 2008. A spot verification revealed that the plots land belonging to the petitioners of writ petition number so and so did not fall within the blueprint map area, but lands were adjacent to the area occupied by the army. The spot verification further revealed that the plot land belonging to the petitioners and so actually fell within the lands covered by the blueprint sketch. The representative of the station headquarters, however, advised the revenue department should verify the ownership of LSC and of the claimant, and since the land appeared to be within the blueprint and rental due to the entire land occupied by the army, measuring 105 bighas has already been cleared and settled by the DO of the state government. Although the land belonging to the petitioners and so did not fall within the blueprint area, but their lands were found to be adjoining the areas outside the blueprint sketch. So that is in occupation of the army. You have to pay the rent.
Lordship, that was adjoining.
Adjoining, but in occupation of the army. Prior to that, they have specifically said the land belonging to the writ petitioners number 14/2010, 15/2010, 70/2010, RFA number 1/2009, RFA number 2/2000 did not fall within the blueprint area, but lands were adjacent
Lordship,
to the area occupied by the army.
Lordship.
Regularization is 17. Hmm. Regularization. About 14 and 67. Impugn order is 17 or 67. No, no, sorry, 17. Of 2000. Page 39. 39. Memo, page 39. That's where it is. Yeah. Different phases of community.
This petition is filed, writ petition is filed by how many persons? Four persons. Those 4 persons were petitioners in writ petition number 67 of 2010. Now, come to this joint verification report. Yes. Compilation of the spot verification further revealed that the plots of land belonging to the petitioners
Lordship,
in writ petition number 67/2010 actually fell within the land covered by the sketch map. These persons are entitled for that.
now these persons got their right over the land in 2004. In
2004,
2004,
from where we got this?
their writ petition, Lordship, the same affidavit, Lordship. The annexure 1 to the writ petition is the writ petition.
Yes, sir.
Yes. Lordship has noticed that the house pass, so far as the petitioners are concerned, was issued only in 2004.
Where is that?
Lordship, annexure 1 to the writ petition, Lordship will find
Annexure 1.
to the writ petition.
Page,
It is page 23. I brought it on record by way of an additional affidavit, Lordship.
that is annexure two, I. Number,
Annexure 1, 2, 3, 4, Lordship.
sure, one, it's somewhat there.
One is K. Lalren Tuengla, the respondent number 1 hearing.
Annexure two.
It was issued on 26/4/2004. In fact, all were issued on 26/4/2004.
Reply to the deputy.
If I may draw your Lordship's attention to page 96 of that same affidavit. In it starts at page 95, at page 96. So far as this house passes are concerned, at paragraph 5 of the reply, what we say,
Of the,
paragraph 5 of the affidavit, filed on behalf of the respondent numbers 1 and 2.
Respondent number?
1 and 2, that is the union lordship. Page 96 of the same affidavit, lordship. We have brought on record.
Yes.
If I may read paragraph 5 of that affidavit.
Yes.
That the statements made in paragraph 3 of the writ petition are denied. However, the respondents submitted that the petitioners are put to strict proof of their alleged pass issued by the erstwhile chief of Chatlang, namely Sailala, in the year 1949, pass number 1 of 1970, white memo number so and so, dated 29/4/1970, and house pass number 143 of 2004, 145 of 2004, 146, and 148. In the meantime, Sri so and so, the then president, Chaltang Village Council, has no right to issue a duplicate pass, 1 of 70, white memo number so and so, to the petitioners. Why? Why the reason is next sentence. The village council has been competent authority to allot house site only after 1953, because prior to that there was no village council. When the Lusai Hills District Act 1953 came into being, prior to 1953, the village council has no power to issue house pass to any person. As per section 3 of the Lusai Hills District Act 1953, a village council is competent to allot site within its jurisdiction only for residential and other non-agricultural purpose. Thus, the village council has no power to allot a house pass prior to 1953. Now, what has happened here? A duplicate pass is issued stated to be issued in 1970, referring to 1949, when the council was not there. And the state of Mizoram became a union territory. Prior to that, it was a part of Assam. State of Mizoram became a union territory in 1972. So, if any pass or any order has to be issued, that would be obviously under the seal of the government of Assam. Not drawing its source from the pass purportedly issued in 1949. A new house pass is issued in 2004. Now, if we were in occupation lordship, I would submit that that could not have been done.
The reply of the state government?
Okay. Lordship may come to page 130.
Yes.
That is one affidavit, Lordship. And again in 161,
Then rejoinder filed by them.
No, minor.
Mr. Chaudhary. Yes, sir. Mr.
Oh.
This, the compensation was to be paid in respect of 3 periods.
3 periods.
66 to 1986, January 87 to 2008, August 2008, and September 2008 to June 2011. So far as regarding first and last part is concerned, this 66 to 86 and 2008 to June 2011, that has been paid. By whom?
The compensation we pay to the government.
To the
State,
government.
to the state government, they disburse it.
They dispersed it. They dispersed it to whom? To these petitioners?
Apparently, Lordship, if
66 to 86.
Yes, Lordship.
And 2008 to 2011. These compensation you have deposited and the state government has dispersed that.
Yes, Lordship.
Who were the persons who are recipient of these compensations? These 4 persons have received that compensation for that period?
It is not in that list, Lordship.
Why?
No, it is in the case, my lord. There is a affidavit filed by the state. 51 beneficiaries have received it.
51 beneficiaries.
It does not include us.
Does not include you.
Yes.
This 66 to 86 and 2008 to 2011.
Yes, there are 3 periods. One, and in the, if you also kindly comes to para 4, they admit they have not paid. Para 4 of their affidavit. My learned friend was referring to para 5. If your lordship kindly come to para 4.
No, just a minute, sir. These writ petitions by 4 persons, you are claiming compensation since when to when?
For the middle period, my lord, that is January 87 to August 2008.
What about this then? You are in occupation of the land since
Yes,
66?
yes.
So 66 to 86, you were paid the compensation?
No, we fall in the middle category, my lord. Our
How?
claim is not with respect to the first and the third. There's
First
no
and third.
dispute on that.
Why?
Because the ministry's affidavit itself says so. That's why I was trying to have a lordship's kind attention to.
January 87 to August
Yeah, that is the
2008.
period. We fall in that category. If a lordship should kindly come to para 4 of the affidavit at page number 54 of the retail paper book.
54.
Yes. That's para 4 of the affidavit filed by them before the learned single.
Yes.
That the statements made in para 2 of the writ petition is denied. However, the answering respondent submitted that joint verification was conducted on 15/11/2011 pursuant to the judgment and order dated 9/6/2011 in WPC number 67 of 2010, where we are parties, and the land of the petitioners fall within the occupied blueprint area. However, in the said report, there is a clear observation made on behalf of the Union of India that rent due for entire area in so-and-so is already paid by the central government to the state government, it was therefore suggested that ownership title of the claimant should be verified because there cannot be multiple owners of the same plot of land. Now, this is important. Further, it is submitted that the entire area measuring 6.99 acre at Bangwan has been dehired on 9/9/2008, and Ministry of Defense is responsible for payment of rent from 1st of September 86 to 9/9/2008 only. The liability, if any, before September 1986 has to be discharged by Ministry of Home Affairs. So far as the Ministry of Defense is concerned, the rent for the entire private land in question at Bangwan has already been paid to the state government reserve, except for the period 1/1/2008 to 9/9/2008 till the period of dehire. So this is a clear case, my lord.
They hear now the question is that how you are you acquired the title of the land?
Oh, my lord, that is not an issue. Their duty, that is a matter between us and the state government. First, they will have to deposit the requisition rent before the state government.
But they have said.
But state government has not raised, my lord, these are all, my lord, these are all afterthought, my lord. Question is, there is no, my lord, there was a verification committee. Verification found that our land falls in very much in that.
Your land falls within very much that, and you are saying whatever the title may be, it is between you and the state government.
Yes,
But what they are saying, we have already paid,
Huh.
here they have already said.
except this period, my lord. Except 1/1/2008 to 9/9/2008.
Lordship, in the judgment, it is very well extracted. That is only for 1/1/2009/9/2008, about
Yes.
7 months or
Yes.
8 months.
Ah.
This is what
So
they are
it's
saying.
not that they have paid the entire amount. No, my lord, this affidavit, this paragraph is very clear. Initially, my lord, they refused to pay us on the ground that it is government land. If a lordship goes by.
Then joint verification report was there and they said, your rent what business. But with the caveat that after this, and what is the state government's stand on this?
Yes, state government stand is very clear, my lord. Now they have filed affidavit here also. Now, if your lordship would kindly take the additional affidavit. And before this honorable court also, they have filed, my lord. It starts at page 418. So lordship would kindly come to para 422. Para 7, 8, and 9. State government has given a detailed calculation, my lord.
No, please.
Yes.
There is a little confusion. The land was in occupation since 1966.
Yes.
Yes. And it remained in occupation up to 2011. With the,
It was dehired on September 2008. It was
okay,
still
up to September 2008.
Huh.
Okay, fine. So it was in occupation of the army till 66 to 2008. The people asked for compensation from 66 to 2008. They, as per them, they have paid the compensation. Now, you're right. You are saying your right is only from January 87 to 2008, August 2008. Why you are not asking for 66 to 86?
Well, that instructions I do not have, my lord. I am going by
Because
the treaty.
how you
No,
acquired the title of the
there is-
land or ownership of the
There
land?
is substance in what has fallen from your lordship. Why from this middle period, why not earlier?
What?
That answer I can have if your lordship wants. But if your lordship kindly come to page 422. of the additional affidavit filed by the state. Para 7. That the respondents, he has a lot of got it.
Yes.
That the respondents herein are also entitled to monthly rent from January 87 to August 2008 as per the appropriate method calculation. Amount payable for the same period from January 87 to August 2008 is 47 lakh and not. And the same amount is given payable by Union of India Ministry of Defense Ministry. A table showing the assessment of the rental compensation payable from January to August 2008, the method of calculation, area of land in square feet occupied by respondent, total amount payable is reproduced here in below. So my lord, the chart is given.
So that there is no dispute about that calculation. If you are, the only question is how you.
That my lord, because it's a matter of single judge, it was in my lord Aizol. That instruction I can have, my lord.
You please and state, you also please insert how they acquired the title over the land in the year 1986 to 2008, not prior to that. Because the land was in occupation since 1966.
There could be a case of change of ownership, whatever it is, my lord.
For whatever reason.
Yes, that I'll have. Just to, my lord, have the chain complete.
Yeah, that's right. That's right. Only this. And if you are in occupation of the land since 1986, what about the earlier period? Because the land is in occupation.
Whether they have received anything.
Whether they have received and who are the owners. That legal and concept for the petitioner, respondent as well as the concept of the state of Mizoram may clarify that how the writ petitioners of writ petition number 67/2017. What is the writ petition number? 17/2016 acquired the title over the land in question in the year 1986 to 2008, August 2000. This exact date is
1 second.
In April.
It will be, my lord, end of August.
January 87 to 2008.
August 2008.
August 2008. January 1987, August 2008. And who are the persons who were compensated for the period April 1986 to 31st of August 1986? You please clarify.
State will also see.
State will also, yes.
66.
April 1966 to 31st of August 1986. List on.
Let it be in the month of June.
It's in the month of July.
July.
Item 20.
My lord, the matter pertains to a circular issued by the government of India, which is germane for the petitioner herein, which is the Employees State Insurance Corporation. And the question whether, it's a very short question, whether those who have been absorbed in the Employees State Insurance Corporation's hospital at Bentota would be entitled to ACP, which is the Assured Career Promotion Scheme, or whether they are not entitled to it because they have been absorbed. Once they were absorbed in a category higher than when they were serving, when they were in government service. So that's the short issue before your lordship. And Lord, I would just point out the circulars and 2-3 dates with your lordship's leave. So, my lord, one of the relevant dates would be that respondents 1 to 53 were absorbed in ESIC on 1/1/2006. Now, my lord, there was at the time on 9th August 99, which would be also pertinent, according to the after the fifth pay commission, there was an adoption of the Assured Career Progression Scheme, which is also called the ACP, for central government employees. This was accepted and by the ESIC. Now, on the issue then was that if someone has been absorbed in government service, whether their absorption in government service, they would be entitled to their past service or would not be entitled to the counting of their past service for the enforcement of the career progression scheme. Now, the circular and the office memo are very clear that if they are absorbed at the same entry level on the same pay scale, then they would be entitled to their past service. And if it is at a higher pay scale, then they would not be entitled. So, my lord, I just need to show the circular 9th August 99 and the clarification dated 10th February 2000. Lord, I believe the 9th August 99 is on page 68 of your lordship's paper book.
Yes, that is of 8th of May, 8th of July 2015? No.
No, my lord. 9th August 99, annexure 3, my lord.
We are page 43.
43.
Oh, God. My lord, my paging seems to be incorrect, but let's go by my friend's paging.
Yes, that is of August 9, 1999.
That's right. That's right, my lord. Now, I'm just going to read a few paras of it. The Fifth Central Pay Commission in its report has made certain recommendations relating to the Assured Career Progression Scheme for the central government civilian employees in all ministries, departments. The ACP scheme needs to be viewed as a safety net to deal with the problem of genuine stagnation and hardship faced by employees due to lack of adequate promotional avenues. Accordingly, after careful consideration, it has been decided by the government to introduce the ACP scheme recommended by the Fifth Central Pay Commission with certain modification as indicated herein below. Now, I'm just coming to the last sentence on this page, which is basically saying, the last sentence on this page, that in relation to Group C and D employees entered into with staff side of National Council under the ACP scheme to Group B, C, D employees on completion of 12 and 24 years. So it's just to show that the ACP scheme was to apply after somebody had done 12/24 years on first ACP and second ACP. Now, if your lordships may just come to the annexure to this, which are conditions for grants of benefits under the ACP scheme. My page numbering is wrong, so it's just annexure 1 to this, my lord. And if I may take, my lord, to clause 12.
Page 47. 47.
Yes,
My lord, clause 12.
yes.
The proposed ACP scheme contemplates merely placement on personal basis in the higher pay scale, grant of financial benefits only, and shall not amount to actual functional promotion of the employees concerned. Such orders regarding reservation in promotion are applicable only in the case of regular promotion. Reservation orders roster shall not apply to the ACP scheme, which shall extend its benefits uniformly to all eligible SC/ST candidates also. Now, however, at the time of regular functional actual promotion, the cadre controlling authorities shall ensure that all reservation orders are applied strictly. I now need to take your lordship to the clarification of 12 to 20. And I'm wondering if your lordship has it with a separate document or within this. It's the OM where the clarification was issued.
Ma'am, page number.
My lord, I can see only the page number in the review file. So I think it was handed over separately to your lordships. But if the review file has come, then it's page 117 of the review file.
There was a review has been disposed.
Yeah.
Yes, I know.
So where is
But
that review file?
I
You
think
don't
this
have
has
that review
been
file.
handed over.
Ma'am, either you should, the notifications or memorandums which you are relying, please file it separately, ma'am. Because now the review application, the review.
I
not
understand.
annexed with this.
I just asked Ms. Das if it's there on your lordship's file.
You please, whatever you are relying on, which documents you file separately.
Very
Because
well.
now it's very difficult to tag the review file along with this.
Yes, I understand that. My lord, my colleague can tell us for the respondents whether this is on your lordship's file or only in the review. I think it was filed.
Their petition, my lord. How can I know which of the cases she will be referring to?
All right. Then I'll just place that on record.
If the dates are told, my lord, then I can tell your lordship, my lord, on which page it is there. But otherwise, I will not be in a position.
Ma'am, you do one thing.
Yes, my lord.
Please file whatever the documents which you are relying, which may not be in the file of this writ appeal.
Very well.
Or writ petition. You file the document separately by supplying
Very
first copy
Very
to another
well.
party.
Very well, my lord.
But if it is,
Very well.
if my learned friend is referring to 10th February 2000, then
Again, it will again, the paging is also not matching and everything is in confusion. It's a matter of review petition. Review petition is not here before us. You lick it. Learn a concept of the petitioner takes some time to place on record the documents, the orders, public memorandums relied by the petitioners separately by filing a separately by filing, separately, full stop. Separately by supplying the copy in advance to the counsel for the respondent. List when it is to be listed?
My lord, if it's convenient to your lordships, 28th May, if it's convenient.
No, it's we can place it on hearing day only.
My lord,
Either Tuesday or Wednesday, Thursday.
22nd May, Lordship.
my lord, then may I
29th,
just suggest a
29th
date?
of May.
My lord, may I suggest a date in June then? Is that possible? Say
Yeah.
25th or 26th June?
27th of June. Sorry, this 26th of June. Okay, 26th of June.
Very well, my lord. Grateful, my lord.
Item 21.
May I please, Lordships? Lordships, in terms of the last order, the government has filed a policy and they have brought it on record. However, the affidavit is not before your Lordships. The affidavit which was filed by the government on Friday. Friday, your Lordships.
What is this affidavit?
Lordships, they have now formulated a policy for granting compensation to any inmate who dies in jail as an unnatural death. So the policy has been brought on record.
That is in relation to?
That was the main issue. The only difficulty in the entire policy would be, Your Lordship, the clause 9 of the policy, by which what they are saying is that this policy would be given only prospective effect. So the entire purpose of filing this PIL before your Lordships, wherein several inmates have been already been identified.
No, it is in relation to only this state of Assam or all other?
No, only in the state of Assam.
This
Yes,
petition
that is the
related to only?
Yes, only the state of Assam. So what the entire purpose of filing the PIL would come to naught if they are allowed to hold that clause 9.
File your
I will file, let their affidavit come on record. Lordship may kindly give me a week's time and take it up next week anytime as per Lordship's convenience.
For the state has submitted that. The policy formulated by the state of Assam for payment of compensation to the victims of the prisons who have suffered unnatural death is already brought on record by way of filing an affidavit on when you have filed the affidavit?
9th of May.
On 9th of May 2025. The copy of the affidavit is not available on record. The registry is directed to place the same on record. Learned counsel appearing for the learned amicus curiae.
No, Your Lordship, I'm the counsel, not the amicus.
Acha, learned counsel for the petitioner waste some time to file counter to the affidavit filed on behalf of the state on 9th of May 2025. Time period for is granted. When?
Lordship's 21st, 26th, as per Lordship's convenience. 21st of May or 26th of May.
When list on 3rd of June.
3rd of June.
3rd
Yes,
of June.
Lordships. Deeply obliged.
Item number 8.
Yes, Mr.
Item number 8, I will require some written instructions. I have asked them. There was a proposal for some.
What about 7 and 9?
7 and 9, my lord, probably I am told that since the state is now done away with, these become instructions.
Huh? What has been done away?
The TET which we had proposed, the special TET which we had.
No. This item number 7 is also regarding TET.
Yes, 7 and 9, my lord. What had happened is we had proposed a special TET to consider regularization of the petitioners who were then working as contractual teachers.
Now their services have been regularized. Your services have been regularized or respondent services?
Possibly, yes, because it's very
What is
difficult.
happening, they've done
This
it with the-
department, I can't say anything because so many contradictions are taking place.
Therefore, Lordship will allow
They will
me,
not know.
Lordship will allow me week's time, I'll bring out.
Yes,
the,
that is better.
Recent developments, by way of an affidavit as to what we have done with the TET.
In August 2023, you made the same statement.
The amendment to the rule came in December 2024, and thereafter the regularization has taken place. That is why I was saying, Lordship will give me a week's time. I'll take it up.
Okay, in item number, this 7 and 9 में लिख देना. Learned Counsel Mr. Majumdar pays some time to apprise the court regarding the status of the respondents at present, based on when.
A week's time.
Next week, दे देना. अच्छा, wait, 20th May. 20th of May, just on 20th of May. And this item number 8, yes.
It also saying.
What
It
about
also, Lordship will keep it for the 20th. Because I have to find out what I find everywhere it is honorary. What my senior colleague has said that they were being paid some amount. And this is really an issue with the department. I'll have to get.
तीनों में यही.
Wonderful. Ola, isn't it? We are not saying anything.
Yes.
Item 22 and 23.
But request your lordship to take up the writ appeal 284 minutes, 283 minutes. And 23 minutes. And may I hand over a list of dates to your lordship? It's a very short point as your lordship is aware, Milord. And Milord, I rely entirely on the fact that both the delinquents here, because both
Confession.
Yes, there's a confession.
Confession.
Confession with an explanation corroborated independently by others. So, Milord, and if I, before that, I'll just take your lordship to the finding in the impugned judgment, page 392, if your lordships will come with us. There's one, it has been dismissed by the learned single judge, is that 2 sentences, Milord. I just want to take your lordships to that, and then I'll take your lordships then to Milord. 392, Milord, your lordship.
Para?
Page 392.
Para.
Para, Milord, there will be in, there's no, it's it's paragraph 29, but it's at page 392, about 10 lines from the bottom, Milord.
Internal page of the judgment.
Internal page of the judgment is 48.
48. Yes.
Your lordship, from the, or 10 lines from the bottom, Milord, a reference is made, your lordship will note.
Yeah.
A reference is made to a purported confession by the petitioner, Sri Diganta Haloi, that these cables were permitted. But 10 lines from the bottom, Milord. A reference is made. Paragraph 20.
Purported confession.
Yes, I'm great.
Yeah.
A reference is made to a purported confession by the petitioner Sri Diganta Haloi that these cables were permitted to be lifted by the service provider in order to compensate him because of a shortfall of the total weightage of the goods to be auctioned as per the auction note. The said concession was, however, subsequently withdrawn by the writ petitioner on the same ground that the same was issued upon a duress by higher officials of the NRL. Under such circumstances, findings arrived at by the inquiry officer in the further inquiry is not based on any material which are shown to be present in support of the charges against the writ petition. So, the fact that it is an explanation, admission with an explanation which he himself says, and not on 3 different occasions, substantiated by physical verification, corroborated by others. I will now, if your lordships will have the list of dates. Yes. Yeah. I will take your lordships with the pages along with the list of dates. The respondent on June, I am reading this from the list of. The respondent number, Sri Diganta Haloi joined Numerical Refinery as graduate engineer trainee. He was later posted as commercial warehouse officer as official materials. Sri Diganta Haloi at the relevant time was working as AM commercial and posted at commercial warehouse at NRL. He was therefore the custodian of the goods at
the learned single judge.
Yes, sir.
Allowed the writ petition on 2 counts. First, the confession was under duress, and second, that the whatever the video recordings were not supported by a certificate under section 65. That
I'm
is
grateful.
the two grounds, and
I-
therefore no material, other material is available on record. That is what.
And I have a third ground. The third ground is that what the learned single judge, he rendered a finding. And actually it's erroneous according to the rules. He says that the procedure for, he has wrongly applied the procedure for premature retirement.
That is compulsory retirement and
Yes,
HRM retirement.
yes.
Yeah.
So that was part. So, but I will take a lordship to confirm because it's a detailed part. So this is where the list of dates, along with the pages, I will not finish in, it won't take much time. So a fire accident, May 2013. A fire accident took place in the crude distillation unit of Numaligarh refinery. Your lordship may have page 100, because there are some notings there. Of the burnt and scrap cable from CDU fire moved to the scrap yard over the page, as evident from the entries in the logbook. This conclusively demonstrates that the entire scrap material, subject matter of the auction, was transferred to the scrap yard. Then, 30th of December 2013, approval is given for disposal of CDU damage, fire damage items to be auctioned in lots. Lot 1 is for ferrous and non-ferrous scrap items, and lot 2 is for burnt cables. The respondent, being the assistant manager commercial, was a signatory to the said approval. It is most relevant to note that it was specified in the said approval that the auction material are in the scrap yard. No other location in the refinery was specified. That's at page 100. Then, 17th of December 2014. E-auction was held in terms of the approval dated 30th of December 2013. Messrs. Telex India was declared the highest bidder for lot 1 and lot 2. It was clearly specified in condition 29 of the business rules, terms and conditions for disposal of scrap material of the auction that the loading and delivery of the auction goods will be permitted only on working days and during working hours of NRL stores. This is pertinent as in the instance case the goods were loaded and delivered on Saturday, a holiday. The relevant extract of condition 29 reads as follows. Condition 29, conditions of delivery. Loading and delivery will be permitted on working days and during working hours of NRL stores, which is at page 429 of my additional F. Now, the 4th of March 2014, successful bidder, Messrs. Telex India, sent an email saying that they will not be able to lift the material for lot 1, as will not be able to lift the material by the price that we have quoted next week. Or the lot as we have wrongly quoted the price for the same. The same mail was forwarded by Shri Pankaj Baru to Shri Ganta Haloi, the respondent seeking approval of the same. So one respondent forwards it to the other. This is at page 433 of the original effort. 4th of March 2014. Approval is given for accepting Mrs. Telex India bid for the second lot, that is burnt cable. With regard to first lot, it was noted that the H1 bidder for lot 1 has intimated their inability to lift the lot, terming they quoted wrongly. The 13th of March 2014. After receipt of payment, delivery order was issued in favor of Mrs. Telex India for burnt cables in double quote. Then 14th of March 2014. Respondent submitted request for deputation of CISF officials for witness. In the request, nature of scrap auction goods was wrongly stated by him to be cut damaged cables instead of burnt cables. The extent quantum of auction goods was also wrongly exaggerated to be 60 metric tons, when in fact the auction goods weighed less than 32 metric tons. Then 15th of March 2014. 3 trucks of Mrs. Telex India were allowed to lift the auction materials of the second lot. It is to be noted that 15th of March 2014 was a Saturday and was a weekly off for the stores department. Regular workmen was either absent from duty on the said day. The 3 trucks of Mrs. Telex India were allowed to lift materials from the locations other than the scrapyard, which is the only location mentioned in the e-auction. The respondent was personally present during the loading process and identified and oversaw the entire process of loading materials in the 3 trucks. Both the respondents were. All gate passes, delivery challans, and invoices were signed by the respondents for clearance of the goods from the appellant's refinery's premises. The delivery challans issued describe the material as all scrap NRL fire damage material, damage cable. This description of the material is that variation in the description of the material set out in the request for deputation of the CISF official for witness, and also the description given in the delivery order dated 13th of March 2024. Furthermore, the description of the material while inviting bids for the auction described it as lot 2 burnt cable. The pages are set up for it. 15th of March 2014, the 3 trucks of scrap cables were seized by the police based on complaints made by media persons and members of student organization. In the complaint, it was alleged that in the name of scrap cables, useful material was taken out from the refinery. After discussion with district administration, it was decided that the 3 trucks will be brought inside the refinery premises for unloading and verification of the allegations made in the complaint. The 19th of March 2014. Complaint was made to the appellant by the local reporters of different news agencies, members of student bodies, etc., alleging that good materials were being sold as scrap burnt cables by the officials of the appellant and seeking an inquiry into the matter. 20th of March 2014. The 3 trucks were brought inside the refinery premises and materials were unloaded in the presence of a magistrate, police personnel, employees of State Electricity Board, person representing the complainants, and technical persons of the Instrumentation Electrical Department, NR.
At 2.
Correct.
Item 22 and 23.
The list of dates I was on 20th of March.
Yes.
I'm reading from the 20th of March date.
Yeah.
The 3 trucks were brought inside the refinery premises and materials were unloaded in the presence of a magistrate, police personnel, employees of Assam State Electricity Board, persons representing the complainants, and technical persons of the Instrumentation and Electrical Department of NRN. The unloaded materials of the first 2 trucks were examined by the technical persons of the appellant and it was certified that the same were not usable. While unloading the materials from the 3rd truck at the bottom, 2 coils of cables of large dimensions were found. After examination, the magistrate ordered the sealing of the cables for further testing. A report by the chief commercial of appellant records that the driver of the truck showed the location within the premises of the warehouse from where he has loaded the 2 rolls of cables, demonstrating the material was lifted not from the scrapyard but from the warehouse. 21st of March 2014. The respondent was informed that a departmental committee was constituted to look into the allegations against him and that he was aware of the lifting of non-scrap materials from the warehouse by the auction purchaser. The respondent was further informed that since the allegations are grave in nature, he was placed under suspension pending inquiry. 26th of March, and this is relevant because there are 2 committees. This is the first committee, the vigilance inquiry, for the 3-member departmental committee. In an examination by a 3-member departmental committee, respondent categorically stated and admitted that unclassified cable have been given to Mrs. Telex India to compensate the latter for alleged loss in forfeiting the EMD for lot 1. The relevant extract in this regard reads as follows. Why the different materials loaded? Party EMD lost rupees 1.65 lakhs approx and requested to consider some compensation personally. So copper cable of rupees 1.7 about 2 metric ton was given as jointly decided with P. Boro, which is one of this at page 473, 476.
P. Boro?
That's the other respondent. That's the senior person. He's the materials manager. I am the assistant. The other one is the respondent, assistant manager. 26th of March, 2014. Statement of crane operators responsible for lifting scrap cables was given to vigilance officers NRL. It was stated that at the instance of Sri Pankaj Boro and Sri Diganta Haloi, cranes were taken inside the warehouse premises and 2 bundles of big cables were loaded in the 3rd truck. The relevant extract in this regard of one of the crane operators, Sri Gopinath Baswaratari, reads as follows. After lunch around 2 o'clock, as per advice of Sri Pankaj Boro and Sri Diganta Haloi, I took the crane inside the warehouse premises. After that, I was shown 2 loose bundles of big cables fencing towards the roadside by Sri Pankaj Boro and Sri Diganta Haloi. By the 755 T crane, I loaded the 3rd truck with the 2 bundles of cable. It is pertinent that the statement was exhibited and marked as exhibit number 52 in the departmental proceedings. Now, I'm 29th of March, 2014. A committee of 4 officers.
Just a minute. Departmental, 3-member departmental committee.
Please, Manoj.
This is the disciplinary.
No. This is prior to institution of disciplinary proceedings. There were 2 committees. One was the vigilance inquiry undertaken by the vigilance department and a 3-member departmental committee who also undertook the exercise of ascertaining. So there were 2 different committees examining the same fact. And the same statements were made and reiterated by them. That's what my endeavor is, but also demonstrate your knowledge. A committee of 4 officers of the appellant was constituted to locate the area where fire burnt and damaged cables of a CDU fire was dumped. The committee answered that the same was dumped inside the scrap yard and in no other location. The relevant extract of the finding reads as follows. Answer by the team member.
What is this? Dump the
Actually, what is the case here? The case here is that when the fire occurred, all the scrap and burnt material from the fire were put in a scrap yard.
At one place.
At one place. What was there in the cable? What was there in the warehouse was goods not meant for auction. auction took place for two lots, lots 1 and lots 2. There were two lots to be auctioned. Now, the successful bidder in lot 2 who lifted this material was a successful bidder in lot 1 also. Now, according to the emails which happened, I shall show to your lordship, he said that he had wrongly quoted the price for the lot 1, and therefore he was not lifting them. That was 1,75,000. EMD was earnest money deposit was forfeited by him. The case set up by the respondents until the filing of the written statement when they retracted it, without assigning any reason, was that because the successful purchaser had suffered a loss in lot 1, he was compensated by giving extra cables, extra material, not part of the auction goods, which were not auction goods, in the auction as part of the auction.
Not part of that dumped material.
Yes, and not part of the auction. That's very important. That's very important because these are not auction goods. So that is what they have said. That was the explanation until for 3.5 months, and multiple inquiries will continue. As they retracted it only, I will show you that to your lordships, only just saying it was under coercion and duress. It could not have been under coercion and duress because you are furnishing an explanation. I am grateful for that. The relevant extract of the finding: CDU, VDU fire burnt and damaged cables were dumped inside the earmarked scrapyard cable only. Behind warehouse by the side of road number 6, which is kept under lock and key. Key remains with warehouse. And in no other location, and the same was shown to the insurance surveyor. So the insurance had also surveyed it, so that was shown. 2nd of April, that's now. A report submitted by 3-member departmental committee recording the finding that both Sri Diganta Haloi and Sri Pankaj Bora accepted that it was illegal to lift cables from the warehouse area. The relevant extract reads as follows. Both Sri Pankaj Bora and Sri Diganta Haloi accept the fact that it was illegal to lift cables from the warehouse area. As per Sri Diganta Haloi, it was done in discussion with Sri Pankaj Bora. However, Sri Bora declines that Sri Pankaj Bora informed that he is not aware of the cable loading from warehouse area. But it was found that during loading from warehouse area, Sri Bora was present in his warehouse office. Now I'm reading 2nd and 3rd of April. This is very relevant. This is the first admission and explanation. Respondent gave a statement to the vigilance officer of NRL where he confessed that he, along with Sri Pankaj Baru, decided to compensate the biller, Mrs. Telex India, by handing over old cramped copper cable of around 1.5 ton running in OY01 for a long period of time. It is further relevant that Diganta Haloi in his time statement dated 3rd of April 2014 has stated that the sum of rupees 1,75,000 being the EMD for lot number 1 would be forfeited by the auction purchaser. It was confessed that that Mrs. Telex India had placed their bid for the first lot on the understanding that some items, airfin cooler and other ferrous scrap, were included in the said lot, and it was not, and consequently they had to withdraw the bid, resulting in the forfeiture of EMD of rupees 1,75,000. And it was to compensate the bidder for this loss that the respondent and Pankaj Baro had decided to hand over copper cable lying in the open yard. A detailed explanation and admission have been made as to why the undamaged cables were passed off as burnt cables in answer to question number 10. Can I take your lordship straight away to that page, because they are page 39 if your lordship will have, because these are 3-4 pages I will show to your lordship, because this is where with the entire admission, and page 39 with the paper book. Page 38. Question number 10, Millards. It begins, Millards, at page 36, statement of Sri Diganta Haloi.
6 or page 38?
30, yes. 36, 37, 38.
Yes.
So this is his statement given to the vigilance inquiry. The third truck, question number 10, Millards. The third truck was taken inside the warehouse to open yard, and one load of crane cables were loaded with the help of crane. Why was this cable loaded in the truck? This is the unauctioned material. This is the relevant part. Now the answer. The tender was for 2 parts. First lot was for 2 parts. First lot CDU, VDU, fire damage, ferrous and non-ferrous scrap materials, and the second lot CDU, VDU, burnt cables. The H1 bidder, Mrs. Telex, had quoted for both the lots while the proposal for award was under process. The bidder came to know that they had wrongly considered certain items for the first lot, such as CDU, VDU, damaged airfin cooler, 6 numbers, and other ferrous scrap lying inside scrapyard, which were actually part of another auction to be held on 24th of February 2014. They insisted that due to wrong information given by warehouse, they had considered these items and quoted a high price. Now they are unable to accept the H1 bid due to the withdrawal of offer, will forfeit their EMD amounting to rupees 1,75,000 for the first lot. The customer demanded warehouse to refund their EMD or compensate their loss of rupees 1,75,000. It was admitted by us that we had given incorrect information regarding the first lot, since the airfin cooler, 6 numbers and other ferrous scrap was not marked as a separate auction. Due to the pressure of the customer, myself jointly with Deputy Manager Materials decided to compensate the customer by handing over old cramped copper cable of around 1.5 tons lying in the OI01 for a long period of time. Approximately 1.5 ton of the cable was given because earlier similar cable was sold for around rupees 85 per kg. Considering this rate of the value of the cable amounts to rupees 1.27 lakhs. Now, question 11. Who had given the incorrect information to the bidder regarding the first lot to include air from fin cooler and other ferrous scrap? I do not know who had given the incorrect information. Then next page, Manoj, it continues because the explanation continues. Because most important, and which is what my endeavor is, it is not a confession. They have given an explanation. Why they did it? And now they retract it, which only shows that the culpability, Milos. These cables were brought to the warehouse between 2007 to 2009 when Mr. B.N. Das and Mr. Gautam Pal was posted in the warehouse. This is known to Mr. Gautam Pal, Mr. P. Boro, Mr. S. Storekeepers, Dipen Chaudhary, and supervisors Mohan Gohain, Hamata Bora, and other persons dealing with cable. Yes, there are other similar cables at present in the warehouse which were shifted from the cable yard to the warehouse in that same time. When were earlier cables sold for around rupees 85 kg and these cables were kept? Similar cables were sold by e-auction during September-December 2013 to Mr. So-and-so. These cables were from instrumentation department and kept in the scrapyard. Regarding compensation to the customer, did you discuss the matter with anyone? Please give their names and designation. The matter was only discussed between myself and Senior Manager Materials, who is the other respondent. The approval note for accepting the H1 bid was cleared by Finance on 3rd of March 2014. However, the next authority that CNG had not approved the note. Please state the reason why DGM CNL did not approve the proposal.
Note, what is this approval?
It would be, I think, regarding this proposal only, giving them, compensating them. Huh? Tender.
Issue the
To issue the e-auction.
What is this?
H1 bid to accept for approval no, but accepting the H1 that the bid of still exercise. There will be approval note.
Okay, so it was for the approval note for the H1 bid. So he did not approve.
Approval note for?
The first bid, first lot.
The highest bid.
Highest bid, first bid, highest bid. And then last question, Madam. Was any scrap disposal done during any holiday off day in the past? If yes, who were present during such dispatches? Yes, we had earlier disposed ferrous scrap on 2 trucks on off day to Mrs. So-and-so in July, August 2013. In the loading, myself, Senior Manager Materials and local bora were present. Now let's page 40. This is in the list of dates itself. I'll just throw that to your lordships just to complete the sequence. This is the physical verification. The earlier statement is of 2nd and 3rd April. Now, at the top left, your lordship will find physical verification couples in open yard OY01, verification done on 9th of April 2014. By the
where you are reading?
Page 40. Next page itself, on the right hand side.
Yeah.
Physical verification of cables in open yard OY01 at the top left, verification done on 9th of April 2014. Your lordship has that, no? Verification done by Sri Santanu so-and-so. Your lordship will come to item 24. Because the columns are material description, instruments, physical quantity, differential quantity. So item 24, LT power cables, so-and-so, 1021 it is mentioned. Then they found the physical quantity to be less, 336. So there's a difference of 635. Of the extreme right column of item 24.
So, what is for this difference in quantity? How they?
Yes, so this after he made the statement, they made the statement that they had given copper cables from the warehouse. A physical verification was conducted by the committee.
They found that 635
was missing. I am grateful.
was missing.
Yes. This is what
that was that material.
That was that material. And which is what he says, he reiterates that on the next date, on 10th of April, next page, your lordship's account.
Yes.
Statement of this is your lordship note the date. Now it's 10th of April. The first statement was of 2nd and 3rd April. Physical verification of 9th April. Now the statement on 10th of April. Yes. Statement of Shri Diganta Haloy, Assistant Manager so-and-so on 10th at Riverview Guest House so-and-so. Your lordship will come to question number 3. Reply to questions of NRL Vigilance Officer. In your earlier statement dated 3rd of April, you have stated that after lunch, around 2 p.m., the third truck was taken inside the warehouse to open yard, and one load of cables was loaded with the help of crane. The materials to be loaded were identified jointly by me and senior manager materials. On inquiry of the same to senior manager materials, informed that although you had discussed regarding compensating the buyer giving a cramp twisted table lying in OI1, yet clearly stated the same was not possible. Please give your views. Now he says answer. On that day, that is 14th of March 2014, after loading 2 trucks at at SS3, lunch break was given by all, including CISF customer and loading party. During lunch break, the customer approached us for the loading of the cables which were meant for compensating their EMD. Both myself and senior manager along with the customer went to the site, and both of us identified the cramp twisted cable lying at O001 and advised the customer to lift the same after lunch break. After lunch break, the customer engaged the loading party to load the material on the third truck. So let's second, 3rd April, first statement, he says this is what they did. 9th April verification, 10th April, he reiterates it. So now I will skip these. This is what I've already mentioned in my items 20, 21, 22 of the list of dates. Your Lordship may come to item 22. List of dates, 10th of June. Item number 23. Memorandum issued to the respondent, enclosing
Item
there
number 22,
23 minutes.
23.
That's a 10th of, I've already read out all this, Your Lordship. So 23, 10th of June. Memorandum issued to the respondent, enclosing therewith a statement of articles of charge, statement of imputation of one's misconduct in support of each article of charge, and list of documents and witnesses, 5 charges of frame against the respondent. It is to be noted that the confession of the respondent was stated in detail in the statement of imputation of misconduct in support of each article of charge. So as far as this conviction admission was detail mentioned, I've referred the pages also, para 4 at page 114. 18th of June and 20th of June, 2014. The respondent, in response to the memorandum dated 10th of June 2014, requested for inspection of certain documents and statements recorded during preliminary investigation. It is most pertinent to note that the respondent did not retract his confession in any of the said communication.
Yes.
Now, 12th of July 2014. Written statement of defense filed by the respondent, where the respondent sought to retract his confession by making the following allegations. It is not his voluntary statement inasmuch as the statement was printed by the authority. He was forced to state the statement under mental pressure and duress of the higher officials. No time was given to him to prepare, read, or write such statement. No details and particulars was given who were the higher officials who allegedly exercised mental pressure upon the respondent and forced him to sign the statement. If I may just pause here for a moment, and I will show this to your lordships as a law laid down by this, your lordships and the Honorable Supreme Court, that when admission is the best piece of evidence that your lordships have, when admission is by way of an explanation, and when the delinquent himself or the accused person himself has come forth with that explanation, if he has to retract, then if there is a retraction, particularly on the coercion, that particulars have to be given. It's not a simple bland statement, because when today the entire explanation has come forth from them as to why they did what they did. It could not have been.
What particulars are required to be given?
As to what it says is, it says that particulars as to how the coercion was exercised, who exercised, when it was exercised, in what form was it exercised.
You mean to say that the particulars of the person, details of the person?
Yes.
Exerted the
Absolutely.
etc.
That, your lordship can just see 130 of the writ appeal, the retraction is there. I'll just show it that to your lordship.
If there, yes, retraction is there, that's another thing now.
Very well, I will follow. The domestic inquiry, September 2014, commenced against the respondent. 10th of February 2015, permission was sought by the presenting officer to produce video clips which were collected from CISF. The same was denied by the inquiry officer on the ground that the same will prolong the inquiry. 20th of March 2015, inquiry report submitted by the inquiry officer. The inquiry officer held out that out of the 5 charges, charges numbers 9, 2, and 5 were proved against the respondent, and charges numbers 1, 3, and 4 were partially proved. The inquiry officer has placed extensive reliance upon the confession of the respondent to arrive at the findings in his inquiry report. The report was communicated to the respondent on 9th of April 2015. 27th of April 2015, representation filed by the respondents against the report of the inquiry officer before directed technical. It is relevant to note that no reference was made to the confession in the said representation. 8th of June 2015, inquiry officer was advised by the disciplinary to conduct further inquiry on charge number 4 against the respondent. Charge number 4 and 6 in respect of the other also, but it's a similar, identical order. 13th of June, Respondent informed by the inquiry officer that he will be advised to conduct further inquiry on charge number 4, DVD containing 20 number of video clips and 6 numbers of still images, in which reliance was placed by the presenting officer was furnished to the respondent. In the proceedings held on 18th of June 2015, presenting officer displayed photographs and video clips and submitted that the material which loaded in truck number so-and-so were also visible in the video clip. The tag number so-and-so mentioned in the physical verification report, exhibit number 46, is also visible from the videos as well as the still images. The only objection of the respondent to the videos and still images was that the item code is not clearly visible and the cables shown in the video clips appear as unusable, cut and damaged. No, the objection was raised about the authenticity of the videos and still photographs. 8th of July 2015. The report on further inquiry submitted by the inquiry officer which held the charge number 4 against the respondent stood proved. 13th of August 2015, representation was given by the respondent against the report of the inquiry officer. With regard to his confession, the respondent once again failed to give any details and particulars about the alleged mental pressure that was exerted upon him to make such a confession. 13th of October 2015, disciplinary committee passes an order imposing the penalty of removal from service, which shall not be a disqualification of future employment. 12th of December, he prefers a departmental appeal. 25th of January 2016, I'm skipping there, the next day. The appellate authority reduced the penalty against the respondent from removal from service, which shall not be a disqualification of further employment to compulsory retirement. The penalty of compulsory retirement was made applicable from 25th of January 2016. Review preferred was dismissed, and review preferred was dismissed and by the respondent was dismissed. The order imposing punishment of compulsory retirement was upheld on 20th of July 2016. December, he filed a review. And the impugned judgment is Now, if I may show your lordships the judgments on this point, on the confession part, I will complete one chain.
Just a minute. Now you just, apart from this confession,
Yes, my lord.
what other evidence was
very
made
well.
upon by the inquiry officer to held that the charges are proved against the person?
I'll take your lordships to the inquiry officer's order. And let me take your lordships to the first one.
Whether this person, just a minute. This Gopinath Basur Matri,
Yes, my lord.
he was one of the witness in the inquiry.
His statement was there, my lord. I'll just take it.
Statement was under the departmental, that's another thing.
No, it was fine. I'll just give you a lordship, my lord. Just a minute. His statement was included in the page 108. Page 115 is a list of documents, 115. Well, more than that.
Whether he deposed before the inquiry officer as a witness.
No, I don't think so. His statement is there. Gopinath Basumatari is that.
His statement before the 3-member departmental committee, maybe these statements were there, whether he appeared as a witness in the inquiry before the inquiry officer or not.
He was not produced as a witness, but I think his statement which he made was put there.
That was the document.
Yes. But there's another document which which I read out earlier, because to complete the chain, earlier one, 4th of March, your lordship will come to at page 433. Your lordship was asking for 433. 433. What additional material is there? Because I'm proceeding on the basis of admitted facts, admitted facts, their own admissions. We don't need it.
That's a statement, but we are simply, we want to just know that apart from this confession, any other evidence?
Yes, this leads up to it, 433.
433?
Yes, this is prior to the auction. This is a mail from Pankaj Baru to Diganta Halai from the other respondent, one respondent to the other. This is of 4th of March 2014. Your lordship has? 433.
Yeah, 433, yes.
Yes, no, my learned friend was asking. Sir, madam, this is from the successful bidder. The amount of rupees 46 for that we have, your lordship has it. Amount of 46 lakhs that we have quoted for the lot scrap materials with Numaliga Refinery Limited, with the e-auction lot number 1, CDU, fire damage versus and for non-ferrous scrap materials dated so and so. We will not be lift the material by the price that we have quoted on the lot, as you have wrongly quoted the price for the same. So hereby we inform you to be taken up by necessary action on the other price of rupees 1,70,000 We have quoted for the lot number 2, CDU, we are agree with the price and we are very much prepared to lift the materials after making you the entire amount that we have quoted in the site. So what they have said, that the successful bidder for both the lots to compensate him. So this is the beginning. This is very important because it completes the chain from the beginning till the end. So on the basis of what they themselves have said, I don't need to go elsewhere.
Sorry, Bala, I'm extremely sorry to interrupt.
Oh, you want to think?
It appears that the paper book that has been served on us. No, this is an additional.
It is an additional affidavit. You have to get the numbering there, no? We did the continuous numbering page. No, it's an additional affidavit.
I don't think.
Yes. No, 430 maybe for 338 for you.
It has not been served on us.
No, it has been given. It has been said. I don't know.
Because the paper book that I am holding.
It has been served. It has been served.
This affidavit is
It is afterwards.
27th of January,
Yes.
2025.
Yes, we filed and served upon them.
Unfortunately,
Take on it. My learned friend shows one thing. This one, this one. He said, because if they were served, both of them were served. Both of them were served. My learned, Mrs. Goswami has it.
I need to know. There appears to be some communication. 2 appeals. We have been served with only 2 sets, my lord. One is volume 1 and one is volume 2.
That was at the outset. This is served subsequently. My learned friend says he's served you. Absolutely. No, we cannot file it without serving.
Yes.
Yeah. So, I take your lordship now to the judgments on this point as to how many. Compilation? Judgment? Compilation has been handed over, to your lordships. On this confession point, then I'll take your lordships to the other part. Yeah, your lordship, they have the first judgment. Fine. I'll take your lordship to the third judgment first, then I'll take your lordship because Swadeshi Pal Balian Malad, page 14. 2004, 12 SEC 92, Swadeshi Pal Balian Malad.
92.
Yes.
This was a case, your lordship will come to page 15. Paragraph 4, at page 18, 16, 16. This was a case where there's an Air Force corporal who had been accused of damaging aircraft and making them unserviceable. Now, during the course of his proceedings, when he was examined in his inquiry, etc., he had said that they had told him that one person cannot do it. He had asserted that yes, one person can do this. Eventually, the inquiry report was also, another inquiry report also came out. Eventually, when it landed up, there were 2 inquiry reports, in that case, not so relevant. But when it came to dealing with the Supreme Court, in paragraph 4, what their lordships observed, and subsequently also, that confession is the best piece of evidence. He himself has said so and offers an explanation. We don't need to look elsewhere. The lordship will turn to paragraph 4. The appellant submitted his explanation dated 30th of May, inter alia, stating that the 2 reports are diametrically opposed to each other and uncounter to each other. A confessional statement that had been made by the appellant in response whereof the stand taken by the appellant in his explanation was that the presiding officer had threatened him of dire consequences and warned him that he would not be allowed to meet his family members unless the confessional statement is given in due apprehending danger to his wife and children. Blank papers were signed by him against his wall and under coercion and the direction of the presiding officer. presiding officer, and it was only thereafter he was released from closed arrest. The explanation was not accepted, and the order of removal from service was passed, by which the High Court declined to interfere. Now, paragraph 6, Your Lordship's come. We have heard the learned counsel for the parties and perused the material on record. It is not necessary to examine the stand taken in relation to the confessional statement, since even in answers given by the appellant during the course of inquiry, he admitted the factum of having caused the damage. The motive behind breaking many wires given by the appellant was that he was fed up with doing extra work and wanted to bring down the serviceability of the aircraft. It appears from the tenor of questions and answers that the respondent was not satisfied. The appellant alone was responsible, as repeated questions were put to him, that it may not be possible for one person to cause such damage. The appellant, however, stuck to the standard it was so possible. He could show as to how he could do it alone. In view of these admissions, the question whether the confessional statement was made under threat or coercion pales into insignificance. We may, however, note that the confessional statement was retracted substantially on 30th of May 1998, despite the first inquiry report, having been admittedly supplied to the appellant on 13th of September 1994. Learned counsel for the appellant, though having not placed on record a copy of the writ petition thereof, read thereof from a few lines to show that certain evidence had been made about the appellants, having found some blank document. In view of the admissions during the inquiry, as aforesaid, it is not necessary to examine in depth the bald and vague allegations, the explanation, submitted more than 4.5 years after retracting the confession. Then Your Lordships may come to the next judgment, which is the one before this, because this one has been relied upon by the Uttarakhand High Court at page 11.
11.
Yes. It is 2015 SCC online, Uttarakhand 901. Here, my lords, Your Lordships may come to the next page, page 12. This is a short one-page order again, my lords. I'll read from the third paragraph. Page 12. There is no dispute that the respondent himself, in his own handwriting, has confessed his guilt and tendered his apology with the undertaking that in future he will not repeat the same offense. Confession is available on record, being paper number 43 of the paper book. S.N. Babulkar, learned senior counsel appearing for the reply petitioner, stated that even for the sake of argument, it is presumed that all the relevant witnesses, that is Messrs. Shruti Vora, who was on duty as manager at the time of incident, and the security personnel who had caught the workmen carrying stolen items with him, were not produced in the witness box, and the inquiry officer who has conducted the preliminary inquiry failed to turn up for the cross-examination. But the fact remains that the workman himself has confessed his guilt. Therefore, it is for the workman to demonstrate as to why confession may not be read against him. On the other hand, Mr. T.A. Khan, learned senior counsel appearing for the respondent workman, has vehemently contended that, first of all, confession does not contain the date when the same was made. Secondly, confession was made by the workman respondent under coercion and duress of the managerial staff of the employer, and therefore it was not a willful concession. Consequently, the same may not be relied upon. Honorable Apex Court, in the case of Delhi Transport Corporation versus Shamla, reported in so-and-so, in paragraph number 7, has held as under. It is a fairly settled position in law that admission is the best piece of evidence against the person making the admission. It is, however, open to the person making the admission to show why the admission is not to be acted upon. Honorable Apex Court, in the case of Swarishi Pal Balian, which I read to Your Lordship, again has taken a view that admission is the best piece of evidence which can be read and relied upon against the person making confession. In view of the dictum of the Honorable Apex Court, now the settled position of law which has emerged is that admission confession is the best evidence against the person making admission confession, and is for the person who has made the confession to explain as to why he has made the admission confession and as to whether admission was made by him under duress and coercion. In the present case, workman respondent has not produced any witness to say that he has made confession under duress coercion. Ball allegation that confession was made by him under duress or coercion is not sufficient to ignore the confession made by the respondent workman. Since the guilt of the workman is proved in the light of the confession made by him, therefore non-production of the other witnesses before the labor court by the employer is immaterial. In my considered opinion, theft is a serious offense. Theft is otherwise a breach of confidence reposed by the employee on the employee. The moment a trust is broken, employee has every right to show the door to the employee. Now, let me take now to the other judgment cited here in the Supreme Court, which is page 19. This is again a case where of ticketless travel, where extra tickets had been shown to be where he had 2004 8 SCC 88. I'll read the paragraph 2 minutes. The respondent workman was found to have committed misconduct while working as a conductor. He had collected money but had not issued tickets as he was found during a checking date bound by the officials concerned. Departmental proceedings were initiated against him and he was found guilty. A charge sheet was instituted to the workman on 22nd of December and he submitted his reply on 30th of December 2019. Subsequently, on 13th of January 1989 and 24th of February 1989, the workman admitted his guilt and pleaded for leniency. Based on his admission, he was found guilty in the departmental proceedings and removed from service. A reference was made to the Industrial Tribunal under Section so-and-so of the Industrial Disputes Act for approval of the order of removal. The tribunal did not accord approval, being of the view that the admission was really of no consequence and the officer who had conducted inquiry had no direct evidence and the statement made by the person who had paid the amount in question before the officer conducting the checking was in the nature of hearsay evidence and was not of any consequence. Accordingly, approval sought for was rejected. The employer challenged the order of the tribunal before the Delhi High Court and a learned single judge, by judgment dated so-and-so, held that the tribunal's view was not defensible. Accordingly, the writ petition was allowed and was directed that approval in terms of Section 33(2)(b) was to be granted to employers to dismiss the respondent workman. The workman assailed the judgment of the learned single judge by filing letters patent appeal. The impugned judgment by which several ILPs and writ petitions disposed of the view of the tribunal was restored and that of the learned single judge was set aside. Now, paragraph 7 is the finding. Your lordships may just come there. We find that the tribunal's conclusions are prima facie correct. Prima facie not correct. The statement made by the passenger who had paid excess money to the checking officer is not in the nature of hearsay evidence. Additionally, the effect of the admission regarding guilt is contained in the letters dated 13th of January 1989 and 24th of February 1989 have not been considered in the proper perspective. It is a fairly settled position in law that admission is the best piece of evidence against the person making the admission. It is, however, open to the person making the admission to show why the admission is not to be acted on. Has he done so? He has not. It's a bland, which is there, my lords, at on 12th of July 2025. Now, my lords, what are the particulars of coercion which need to be your lordships may come to the first judgment now. First judgment, my lords, that now I will, because this is a case of coercion, alleged coercion in some entering into an agreement. You'll also come to page 8, paragraph 22. There are 3 paragraphs, my lords, or 4. It's 19, 51 SCC 447. 51 SCC 447. SCC, like I'm calling it. Paragraph 22, your lordship has. Page 8, my lords, running page. Yes. We turn next to the questions of undue influence and coercion. Now, it is to be observed that these have been separately pleaded. It is true they may overlap in some cases, but they are separated and non-separable in categories in law and must be separately pleaded. It is also to be observed that no proper particulars have been furnished. Now, if there is one rule which has been better established than any other, it is that in cases of fraud, undue influence, and coercion, the party pleading it must set full particulars, and the case can only be decided on that particulars as laid. There can be no departure from them in evidence. General allegations are insufficient even to amount to an averment of fraud, of which any court ought to take notice, however strong language in which they are couched, and maybe the same applies to undue influence and coercion. See Order 6, Rule 4, Civil Procedure Codes, where the same thing is reiterated. Paragraph 23. The allegations of the paid regarding this part of the case are as follows. In para 13, the plaintiffs say that the said Firangi Rai being infuriated by the filing of the said suit put such pressure upon the father of the plaintiffs that the father of the plaintiffs, under fear of his threatened death, filed a compromise in the said suit before any written statement was filed by Firangi Rai and the other defendants. In para 15, they say that the said compromise was nothing but a dictated mandate of Firangi Rai to which the father of the plaintiffs, out of sheer fear of Firangi Rai, submitted against his own free will and signed under compulsion, compulsion and coercion and the influence of the said Firangi Rai. Now, again, this is reiterated 24. Now, 25, what do they say? What are the particulars they like to be? We will deal with the case of coercion first. It will be seen that the plaintiff's case regarding that it is grounded on a single allegation that their father was threatened with death. When all the verbiage is cleared away, that remains as the only foundation. The rest, and in particular, the facts are on paragraphs 8 to 12 about the ferocious effurience of Firangi Rai and his allegedly high-handed and criminal activities and his character are only there to lend color to the genuineness of the belief said to have been engendered in Bhuguli Rai's mind that the threat of death administered to him was real and imminent. But as regards the threat, still there is not a single particular. We do not know the nature of the threat. We do not know the date, time, and place in which it was administered. We do not know the circumstances. We do not know who did the threatening. Now, when a court is asked to find that a person was threatened with death, it is necessary to know these particulars. Otherwise, it is impossible to reach a particular proper conclusion. It was argued that it was necessary for a plaintiff to give particulars, and if the other side is not satisfied, the provisions in the code which entitled him to ask for them. This is a grave apprehension. But all that apart, what is the evidence here? There are only 3 witnesses who need to be considered, as the others had no personal knowledge. They are number 6, Sheo Kumar Dubey, number 9, Bodhurai, and number 10, Shionandan Paswar. Of these, only Bodhurai suggests that Firangi ever made any threat. Here, no evidence, no witness has been tendered here in this case that there was about threat and coercion. He is not supported by the other 2, and we cannot believe him. All that the others say is that Buguli Rai said his wife would be in danger without, however, explaining how or why. That is insufficient to sustain pleas of undue influence and coercion, particularly when you have the following facts which negative these pleas. 2 pleaders were engaged by Buguli Rai. The first draft was torn up by one of the pleaders as it was unfavorable to his client, and the draft embodying the compromise ultimately accepted was substituted. Buguli Rai refused to sign the second draft until it was read out to him. Until this draft was read over by the pleader, but disapproved the first draft. It was signed by him after Guguli Rai had signed. Guguli Rai resided in the compromise on several occasions and filed suits to enforce his term. He twice sued Firangi Rai himself. Even though he lived 11 years after the compromise and filed several suits to enforce it, he never suggested it had been brought about by coercion or undue influence. He took no steps to set it aside or question it, even after Firangi Rai's death, which was even 2.5 years before his death. He did not join as a plaintiff in the suit, even though he was the real person who knew the truth. There is nothing in the evidence to suggest when the anti-influence ceased, and we find it impossible to believe to have lasted 11 years and even 2.5 years after Firangi Rai's death. So no particulars, no witnesses, just a bland denial is what they have said over here. And your Lordship was asking about some particulars. Now, the retraction part, because as far as retraction is concerned, your Lordship may have page 457 of this, because what this particular respondent has said is corroborated by the other respondent at page 457, 458. Your Lordship is important, because since your Lordship was asking how to support it, 457, 458. This is the other respondent who was examined when he was examined by the vigilance officer. It starts at 453 and it's at 457, question 18. Your Lordship is question 18. In a statement to the vigilance officer of NRL, Diganta Alai stated that, this is what I've already read out to your Lordship, that he did it in consultation with Mr. Pankaj Boro. Your Lordship is question 18 minutes.
457.
Yes, minutes. Question number 18.
Yes.
In a statement, your Lordship has, in a statement to the vigilance officer of NRL, Diganta Haloi stated that. Now, I read this out to your Lordships already, that the customer had demanded the entire thing about how he had consulted with the other respondent. Please give your views on the above. And what does he say? It is a responsibility of Diganta Haloi and Nukur Abdullah to select the correct materials to each materials against each auction to the bidder. If any wrong information has been given to any bidder, it is their fault. Over the page. Before issue of delivery order on 13th of May, this is important, 458. Before issue of delivery order on 13th of March 2014, Diganta had told me that there was some mistake during the showing of the auction materials of the first lot and discussed with me if it is possible to refund the EMD. I stated that as the bidder had already quoted and submitted acceptance letter, it was not possible to refund the EMD at that point of time. Further, Diganta also told me, intimated that the party had earlier forfeited an amount of rupees 1.4 crores in an earlier auction. The party has requested for releasing the EMD to compensate their loss towards the EMD by giving a clamp twisted cable which was lying in OI. I had clearly stated that the same is not possible.
Who is he?
He is the other respondent. He's the senior manager.
So he denied that.
No, he
denied his own.
He denied permission. He in his statement says he denied permission to the respondent I'm dealing. This is the respondent, the other detail.
Permission is the junior one.
Huh.
So he said, no, I have not agreed to whatever the Pankaj Haloi was saying. He was not agreeing to it.
So this is what they have said now.
Diganta Haloi.
Huh. So he has said the senior one is telling the junior one, he in his statement, so what he said. that this is what I told him not to do. So it is not that, so this only corroborates what, and both of them were present when the cable was loaded. When the cable was loaded, the warehouse premises on an off day, or both of them were present.
So then in that case, the confession, whatever the confession in respect of Diganta alloy is there, but so far as regards this Pankaj Boro, no such confession is there.
There isn't a confession, but because he denies it. But his presence is there. Very important. He's a senior manager. He is a senior manager. He was present in the warehouse premises. It is all recorded. He was present in the warehouse premises and it is not disputed. When the material was lifted and sent out.
Okay. Yes.
Now, so this is one part. Now, the procedure for premature retirement. In paragraph, para 34, the judgment. Because this is an error, it's quite eating. So, because this also will come in the way of it is page 399. It is all there, 3 pages on confession, then the contract.
Para 25.
34, page 399.
Internal.
58.
Sorry, Manoj?
Internal page of the impugned.
55.
Yes.
Insofar as the orders of the appellate authority is concerned, it is seen that the appellate authority by an order dated 26th of January 2016 has modified the imposition of penalty of removal from service to that of compulsory retirement. As discussed above, the provisions which calls for an order of compulsory retirement are described in detail under Rule 9 of the said rules. The criterion for judging medical unfitness, inefficiency, or doubtful integrity of the management staff proposed to be prematurely retired as specified on the.
So that this Rule 9 doesn't pertains to compulsory.
No, it pertains to premature retirement. Compulsory retirement is a major penalty, and the Rule 6 is applicable there. Your Lordship will come to page 59 of the writ appeal. So, having framed the wrong question, then he says the procedure was not followed. Your Lordship will come page 59 of the writ appeal. The rules begin from 42. At 58, it begins there's an amendment to the conduct and disciplinary rules sometime in 20 prior to this process. At page 59, major penalties your Lordship will see, and item G, compulsory retirement.
Yes. Compulsory retirement.
So your Lordship will have major penalties at page G, items compulsory retirement. Your Lordship has that. Then your Lordship may come to Milad's page 44 of the writ appeal. It sets out the penalties.
Yes.
Page 44, penalties. The following penalties may be imposed by management staff as hereafter provided, etc., etc. Now your Lordship will see the explanation at the bottom, because these penalties have been expanded later on from what I showed your Lordship, because it was by corrigendum. Explanation: the following shall not amount to a penalty within the meaning of this rule, namely, your Lordship may turn over the page 45, at item 6, Roman 6.
Yes.
Premature retirement of a management staff and attaining the age of 50 years on grounds of medical unfitness, inefficiency, or doubtful integrity under Rule 1. So the major penalties by explanation itself says that this is not a and the procedure is at page 48 for major penalties.
48.
Yes, rule 6.
That the London single judge himself has quoted. Rule 6, London single judge himself has quoted in.
Yes, but when it came to the finding, Milord, he gave the premature retirement, which is at page 450, at 53.
Oh, no, then he must have given this finding that this penalty was not in the form of major penalty. The compulsory retirement or removal from service was not.
So what happened here was therefore that rule 9 procedure, by applying that, and they had no grievance on the procedure part.
There is no question of applying the Rule 9 procedure because the disciplinary authority has imposed a penalty of removal.
Please, Milord.
There was no question of, at that time, he has not imposed the penalty of this permanent or
Premature
imposed
retirement.
the penalty of
Yes.
this compulsory retirement.
Yes,
Appellate authority has diluted that.
yes.
So there is, where is the question of following Rule 9 at that time?
Because it's an error, I think.
Supposed to take into consideration the procedure provided in the Rule 9.
And he did not. It's only a finding.
There was no, it was not a case of premature retirement on completion of age of 50 years or attaining the age of so and so. These finding absolutely, there is a question of following that procedure laid down under Rule 9. When the inquiry was for major penalty.
Perhaps, my lord, what has happened is this compulsory retirement as major penalty has come in subsequently in the rules by way of an amendment. And the rules that were placed before the learned signature perhaps did not have that amendment. If your lordship will kindly come to page 40.
No.
If your lordship will kindly come to page 40 for a moment.
40?
Page 40, the first volume.
Yes.
The rules started, page 40. I'm sorry, my lord.
No, no.
The rules started, my lord. Page 42, I'm sorry.
42, yeah.
If your lordship kindly comes to penalties at page 44.
Yeah. Major penalties.
Major penalties. It originally did not have compulsory retirement as a major penalty at all. And it is only subsequently that this amendment came in, which my learned friend has just placed. If your lordship will kindly come to page 58.
Page?
58. This is a subsequent amendment.
Just
and this amendment.
58.
The lordship will find subject is amendment of the conduct, discipline and appeal rules. And
6th of?
This is, well,
It's a corrigendum.
What is the date? Of which year?
6th of June, of which year?
We're trying to find out. That is the catch.
I think my.
Huh?
That is where the catch is, ma'am. This
the
amendment,
But there is no catch there for the.
if this amendment, we are not even aware what is the date of this amendment. If this amendment was not even applicable at the relevant point of time.
It can be ascertained.
No,
Yes,
that
that
will
is
ascertain, but what my learned. But from
And
what?
if your lordship kindly comes to page 59, the lordship will find at page 44, it stops at subclause F, that is dismissal. And compulsory retirement is brought in as G later on at page 59. So
Thereafter, H, I also.
H and I also have been brought in. But one of the first issues would be, what is the date of this? Because the copy that has been served on us, it does not even reflect the date properly.
I think it'll be there in the pleadings. Let's do it.
There's absolutely. And if we take it away from the purview of these rules, the only possible rule that could have been fallen back on was Rule 9. That is why perhaps the learned single judge had to fall back on Rule 9.
No, but even then, my lords, the
Yeah,
learned,
that's exactly what the first question
my learned friend, that is not correct. But if your lordship sees page 42, what my learned friend was pointing out, page 42, page 44. The penalties itself at explanation makes an exception. The premature retirement, if your lordship comes to page 44. When the penalties are set out, the penalties may have been expanded. FGH maybe have been expanded later on. But the explanation says that these are not to be construed as major penalties. Over the page and next, explanation 1. So whether this was available or not.
But this amendment took place in which year, sir?
That is the most important question.
No, I'll just get that. We may have pleaded it also. I'll just tell you.
And what my learned friend is submitting, if it was not available, in that case, my compulsory retirement could not have been imposed at all.
That is not
We are not going to.
That was not argument before the learned single judge.
That was not our argument because that was never the argument of NRL before the learned single. It would have only come by because the reason is very simple, man. Here is a
premature retirement is not a penalty.
No, we
Not a
appreciate.
penalty. Then the procedure, what the purpose of this premature retirement was not supposed to be taken into consideration by the disciplinary authority because it was an inquiry for major penalty.
Appreciate.
It was
I fully appreciate. What I was trying to.
Up to that extent, the learned single judge, where the learned single judge has opined that the rule has not been followed, Rule 9, the procedure for the premature retirement has not been followed, therefore the order is bad. That we feel that is not correct.
6th of June 2011, I am instructed. It's 6th of June 2011.
6th of June 2011.
Yes, sir.
Then, in that case, that was after this, prior to that, the initiation of the disciplinary inquiry. That is what.
All these were, my lord, not even when we put a challenge to, we had put a challenge to all the orders.
Which orders?
The first order imposing a penalty of removal, subsequent order, we have in fact challenged the inquiry also, the inquiry reports also. And
it's another. But so far as regarding this finding of the learned single judge, it seems it is somewhat in doubt.
The reason was, my lord, this as a point was never pleaded by another.
By
Numaliga. We had simply put a challenge on various grounds. Now, NRL never said at any point of time that Rule 9 is not even applicable because there is already an amendment. And by virtue of that amendment, compulsory retirement is a penalty.
In your petition, was there the challenge to the removal order on the ground that the procedure under Rule 9 has not been followed?
No.
Then how do you respond to it, sir? There was the question of responding to this question.
Because this issue of amendment, what I'm trying to point out is something else. If your lordship kindly comes to page 42, what transpires is the rule as it originally stood did not have compulsory retirement as a penalty.
So this is not the finding of the learned single judge. The learned single judge has nowhere said that this compulsory retirement is never a major penalty and therefore it has wrongly been imposed. It is not the finding.
No, that is why I am not saying that it is a finding. What I'm trying to say is perhaps because compulsory retirement was not found amongst the penalties, the only thing that could have been minus the amendment. The only thing that the learned single judge could have fallen back on was Rule 9, where because the language employed, if your lordship will kindly come to Rule 9 for a moment. If your lordship kindly comes to Rule 9 for a moment, the lordship will find page 53. If your lordship has a look at that sub rule 1 of Rule 9.
Staff who have attained 55 years, 50 years, and was considered to be medically unfit or so and so, then rule
Of doubtful integrity. So that perhaps led to
Rule 9.
Rule 9(1) month.
9.
9(1) at page 50.
Yeah.
A staff who has attained the age of 50 years and is considered to be medically unfit, inefficient, or of doubtful integrity may be prematurely retired. Perhaps use of the word doubtful integrity led to the understanding of the learned single judge that since compulsory retirement is not even provided, they must have applied Rule 9.
This is not the
tenor. I appreciate.
The learned single judges simply gone into this, that premature retirement. It seems that the learned single judge understood that this penalty is premature retirement and not of compulsory.
Compulsory.
That is because the disciplinary authority has conducted the inquiry or department inquiry for inflicting major penalty, which includes compulsory retirement and not premature retirement. So there is no question of following this procedure for at the time.
To that extent, my lord, I cannot.
That is. I think that will take into consideration whether this retraction from the confession, how far it is to be taken into consideration. But apart from this confessional statement, what other evidence is available?
I'm coming. The 65A and B, the third part, which is section 65, evidence.
Yes, that is video clips.
Video. Because the learned judge has dismissed it on the ground, has rejected on the ground that the procedure we followed was by furnishing affidavits in terms of section 65A and 65B. Yeah, which is the paragraph 33. I will just read out that and then I will take it. Internal page will be 32, 30, will be 33, will be 54.
Yes.
Paragraph 33.
Yes.
Under such circumstances, and view of the law clearly laid out as above, the DVDs containing the video clips and the still photographs, which were the basis of further inquiry, cannot be considered to have been proved in evidence as per the procedure prescribed under section 65A, capital A, and 65 capital B of the Evidence Act, read with the findings of the apex court and so, and were followed in the subsequent judgments Arjun Pandit Rao Khokar. The acting resolution will have to be held that the findings of the inquiry officer and the further inquiry conducted in respect of the DVDs are not sustainable in law. The contents of the DVDs cannot be held to have been proven in evidence, which is acceptable in law as per the procedure prescribed under 65A and 65B of the Evidence Act. Consequently, the findings arrived at by the inquiry officer in the further inquiry are to be held based on no evidence. The further consequence of the finding is that the decisions. So this is because the procedure under 65A and B was not followed. Now, my submission in this regard, threefold. Firstly, if your lordship will come to page 28, paragraph 28, which is internal paragraph.
With the learned single judge, while relying on a Supreme Court judgment, has said that this evidence act is not fully.
Yes.
That is there.
Yes. I am grateful to your lordship for such a thorough. So, since your lordship, but since it is paragraph where it is said it is not strictly applicable.
The apex court held that the provisions of the Evidence Act may not be strictly applicable in the department, but the principle of natural justice are.
Yes.
You are referring to this.
Yes, I am grateful to your lordship. I'm extremely grateful. So having now my lord said one thing at one place and then to turn around and say, and what is the law otherwise on this? Now, my lord, it is clear from a perusal of the two inquiry reports, the first inquiry report, 20th of March. Your lordships, I mean, once I can take your lordships, but both the inquiry reports, 20th of March is at page 140.
That is by the three departmental.
No. This is the inquiry report on disciplinary proceedings.
Okay. So two inquiry reports, which two?
Oh, no, sorry. The 20th of March and the second inquiry was undertaken pursuant to directions to conduct for. Yes, I'm sorry. I'm grateful to your lordship. Both these state reports rely on the admissions confession statements made by the delinquent and which is corroborated by the explanation also supported by documents.
Just two inquiries. Which are the two inquiries?
One is a vigilance.
Vigilance inquiry prior to departmental inquiry.
Yes.
That
Which
is three-member departmental committee or something else?
I'll show that to your lordship, Vinay.
That was a three-departmental committee in this compilation.
Yes. I will take your lordship to that straight away.
Committee of 4 officers of the appellant constituted located there now. This is not sorry. Report submitted by three-member departmental committee. Is it the vigilance?
Vigilance is separate. It's at page 476. Your lordship will come to page 476. Vigilance separate. Yes, there are two inquiries. That's what my case is. One is vigilance. (473) is a typed version. It is a statement. 472 it begins before the vigilance inquiry. Cross-examination of your lordship. 472. 472 and 473 is the 473 handwritten one. 472 and 473 are a typewritten. Your lordship has 472. Cross-examination of Diganta Hallow in connection with the sale of fire damage articles on 26th of March 2014. This is the vigilance. Now your lordship will come to page 473. Question number 11.
Yeah.
Why the different material was loaded? Party EMD lost rupees 1.65 lakhs approx and requested to consider some compensation personally. So copper cable of rupees 1.75 lakhs was given as jointly decided with P borrow. And this is what is handwritten at page 476.
How many inquiries were conducted?
Two. One vigilance and one three member. Prior to the disciplinary proceedings.
These were, my lord, in the nature of preliminary inquiry. There was one three-member departmental committee and there was a vigilance.
This is the second.
So these two were in the nature of preliminary inquiry. Thereafter, my lord.
Fact-finding, preliminary
Yes.
inquiry, whatever.
So these are fact-finding.
Thereafter, my lord, the show-cause notice was issued and the actual disciplinary proceedings started. So these two that my learned friend is referring to, first three-member departmental committee.
That is at the best material on which the department is placing reliance.
Yes.
Before the disciplinary
Inquiry committee. And the inquiry
itself is dated, my lord, 10/6/2014. All this was happening much prior to that.
which only shows that when they were not on guard, they gave the true story. When they came on guard, then they retracted only bland. So this is why the difference, and this is handwritten. So he himself says that he and P borrow was given as jointly decided with P borrow. That's the other response. So there were two inquiries. Say first, Steelex sends that mail saying that I have lost so much money. It is forwarded by one respondent to the other respondent. He then says that I am giving you we give it off to them on 3 different dates in between physical verification. It's only when the actual disciplinary proves that they do adjust. And in physical verification, it was established, corroborated. So it is on that basis the inquiry report, which is for 2015, that the inquiry officer's report is based on the confessions. Because and as your lordship has seen, it's an open and shut case that way. Admission is the best piece of evidence. They have themselves said, we did not ask them to give an explanation. They have themselves come up with an explanation. They have supported it with a mail saying that he offered that I have lost so much money. Why didn't you compensate me? And he will go and choose the cable. And he chose the cable during the lunch break. During the lunch break, they went into the warehouse premises and they identified the cable. And the third truck was therefore loaded after that. So as far as this part, I'll just finish on the other part. On the 65A and B, your lordships. So when the entire sequence of facts is established and admitted by them, the question of therefore denial or denying whatever was said in the DVDs does not stand to here. And now, there is one judgment in this compilation, State of Haryana versus, sorry, I'll give you the citation. 1977 to SEC 491. It is at item 5, page 22 minutes. The Justice Krishnaya judgment, where he has the nature of 23 minutes. I'll read from paragraph 3 and 4 and 5. 3. Bottom ones. The principal ground on which the courts below have declared a termination as bad that none of the 11 passengers have been examined at the domestic inquiry. Secondly, it has been mentioned that there is a departmental instruction that checking inspectors should record the statements of passengers, which was not done in this case. The explanation of the state is borne out by the record. It is that the inspector of the flying squad had said that they had paid the fares, but they declined to give such written statement. The third ground which weighed with the courts was perhaps that the co-conductor of the bus had supported with this evidence the guiltlessness of the respondent. It is well settled that in a domestic inquiry, the strict and sophisticated rules of evidence under the Indian Evidence Act may not apply. All materials which are logically probative for a prudent mind are permissible. There is no allergy to hearsay evidence, provided it has a reasonable nexus and credibility. It is true that departmental authorities and administrative tribunals must be careful in evaluating such material and should not glibly swallow what is strictly speaking not relevant under the Indian Evidence Act. For this proposition, it is not necessary to cite decisions, not textbooks, although what we have been taken to the case law and other authorities by counsel on both sides. The essence of a judicial approach is objectivity, exclusion of extraneous materials, or considerations and observations of the rules of natural justice. Of course, fair play is the basis, and if the perversity of arbitrariness, bias, or surrender of independence of judgment vitiate the conclusion, reach such findings, even though of a domestic tribunal, cannot be held good. However, the courts below misdirected themselves, perhaps in insisting that passengers who had come in and gone out should be chased and brought before the tribunal, because this is a case of ticketless travel, before the tribunal before which a valid finding could be recorded. The residuum rule to which counsel for the respondent relied, based upon certain passages from American jurisprudence, does not go to that extent, and nor does the passage from Halsbury insist on such rigid requirement. So, simple point is, was there rules governing was there some evidence or was there no evidence? Not in the sense of the technical rules governing regular court proceedings, but in a fair common sense way as men of understanding and worldly wisdom will accept. Viewed in this way, sufficiency of evidence and proof of the finding by a domestic tribunal is beyond scrutiny. Absence of any evidence in support of a finding is certainly available for the court to look into, because it amounts to an error of law apparent on the record. We find in this case that the evidence of Chamanlal, inspector of the flying squad, is some evidence which has relevance to the charge level against the respondent. Therefore, we are unable to hold that the order is invalid on that ground. Reliance was placed earlier stated on the non-compliance with the department's instructions. The statements of passengers should be recorded by inspector. These are instructions of prudence, not rules that bind or vitiate in the violation. In this case, the inspector tried to get the statements, but the passengers declined. The psychology of the latter in such circumstances being understandable, although may not be approved. We cannot hold that merely because the statements of passengers were not recorded, the order that followed was invalid. Likewise, the re-evaluation of the evidence of strength on the strength of conductors' testimony is a matter not for court, but for the administrative tribunal. In conclusion, we do not think that the courts were right in overturning the finding of the domestic tribunal. Now, let's, in proceedings, under 226, there is one judgment, and I'll give you a citation to the otherwise to your lordship. It is judgment number 75 to SCC 557, which is 26.
To SCC 557.
Yes. 557. It's there, my lord. I'm part of the compilation.
26.
Yes.
Yes.
State of Andhra Pradesh and others versus Chitra Venkata Rao. My lords, I will, if your lordship, paragraph 21.
Yes.
No, page 20, paragraph 21. I'm sorry, my lords.
Yeah.
The scope of article in 226 in dealing with departmental inquiries has come up before this court. Two propositions were laid down by this court in state of APR versus Sri Rama Rao. Firstly, there is no warrant for holding that in considering whether a public officer is guilty of misconduct charge against him, the rule followed in criminal trial that no offense is not, that an offense is not established unless proved by evidence beyond reasonable doubt to the satisfaction of the court must be applied. If rule be not applied by the Domestic Tribunal of Inquiry, the High Court is in a petition under Article 226 of the Constitution is not competent to declare the order of the authorities holding a departmental inquiry invalid. High Court is not a court of appeal under Article 226 of the decision of the authorities holding a departmental inquiry against a public servant. The court is concerned to determine whether the inquiry is held by an authority competent in that behalf and according to the procedure prescribed in that behalf, and whether the rules of natural justice are not violated. Secondly, where there is some evidence which the authority entrusted with the duty to hold the inquiry is accepted, and which evidence may reasonably support the conclusion that the delinquent officer is guilty of the charge. It is not the function of the High Court to review the evidence and to arrive at an independent finding on the evidence. The High Court may interfere where the departmental authorities have held the proceedings against the delinquent in a manner inconsistent with the rules of natural justice, or in violation of the statutory rules describing the mode of inquiry, or where the authorities have disabled themselves from reaching a fair decision by some considerations extraneous to the evidence and the merits of the case, or by allowing themselves to be influenced by irrelevant consideration, or where the conclusion on the very face of it is so wholly arbitrary and capricious that no reasonable person could have ever arrived at that conclusion. The departmental authorities are, if the inquiry is otherwise properly held, the sole judges of facts, and if there is some legal evidence on which their findings can be based, the adequacy or reliability of the evidence is not a matter which can be permitted to be canvassed before the High Court in a proceedings under Article 26. Now, they go rely on other judgments with the actual.
That vigilance inquiry, you have pointed out the statement of one Pankaj Boro. Whether this the first person Diganta, his statement was also recorded there.
Yes, yes. His statement is recorded. Page 38.
Page?
38. 38.
No, before in the vigilance inquiry, not before the three
That is, yes.
departmental committee.
No, this is vigilance. 36, no? Sorry. 36.
Sir, in this page 466, these are the statement of Pankaj Boro.
Yes.
In your additional affidavit, along with the additional affidavit you have filed.
Yes.
466 is the statement of Pankaj Boro.
Please, madam.
Similarly, the statement of this another person, Diganta, follow your, what is his name? This statement was also recorded in the vigilance inquiry?
In the 40, page 40.
Page 40? How page 40?
Page 36. 36, but that's the vigilance inquiry. It's the vigilance inquiry.
Page?
36. What I showed to your lordship. There were two committees. Huh? The 3-member committee of one. Just a minute, what I had shown to your lordships is the vigilance inquiry at page 37, 38, question number 10.
Before the vigilance inquiry.
Yes. Reply to questions of NRL vigilance officers. It is written at page 36A. No? And page 472 is the statement for the committee. As my learned friend has rightly pointed out.
And
this is not Pankaj Boro's. I'm sorry, madam. Page 472 is the statement before the committee.
Committee?
Yes. It's the other way around.
Of whom? Committee, the statement by whom?
By Diganta Halad. Question number 11.
So he confessed before the vigilance committee as well as the departmental committee.
I'm grateful for that. No, they were also, I'm sorry, madam. No, the same. No, but the affidavit says otherwise. No, I'm sorry. How do you know this is for the committee? The affidavit comes on.
So you just please show us this the statement of both the delinquents were recorded in both the inquiries, both the fact-finding inquiries or not?
Yes, yes, yes.
Three-member departmental committee, vigilance committee, in both the inquiries, their statements were recorded separately or not?
Yes, yes. I know what your lordship is asking me, whether, where are the statements? Where are the statements? 474, if you see the affidavit.
Whether the confession was before both the, in both the inquiries or in one of the inquiry or, not there in one inquiry and there in another inquiry, what is the?
I'm coming to that one. I'm seeing her. Well, how do you know it is close to this? Huh. Hmm? Hmm. So this was wrongly mentioned, yes, yes. Yes, huh. What my learn? Yeah, sir. Part of the record. But for everybody's convenience. For everybody's convenience. I'm sorry.
क्या हुआ?
आप आपस में बात, I'm sorry, your lordship also.
क्या आपस में बात कर लेना बात?
Sorry, because your lordship was doing आपस में बात. I'm sorry. So I've cross-checked my learned friend. Yeah, this is because this is not 26th of March. The others are 2nd and 3rd April. What I showed to your lordship is 472. And 475 is the handwritten one.
No, please. Now clarify whether their statements or confessions were recorded in both the earlier inquiries apart from the departmental inquiry or not?
Yes, yes.
Or in the one inquiry or in the two inquiries, whatever, what?
I follow. In the disciplinary proceedings, they retracted. In the
That is there.
I understand.
That is there.
Will your lordship just give me 1 minute? I'll just look at it. No, I'm looking at something else. Report to firm.
Get it confirmed day after tomorrow.
The difficulty is, my lord, when we asked for these documents, they outrightly refused. So that is one of the grounds.
Which document?
All these documents that they relied on during the disciplinary proceeding, they did not even give it to us. And that is part of the record.
My learned friend has not read the affidavit. I think this is what we checked with them. We have made out a chart, I think, in the affidavit where.
Counsel, please clarify it.
Yes.
What was the position, whether these statements were confessions were recorded or they have confessed their crime before the two authorities, one authority or whatever it may be. Please.
I'll do that.
Day after tomorrow.
Very good.
May I pray that let them file it by way of an additional affidavit, because we will need to know what they are relying on. Otherwise, then
if it is there in the record, then there is no need of finding an additional affidavit for that purpose.
So far as the three-member committee is concerned, my lord, I have also had a look.
If it is not, it is not. They'll have to clarify it. If they have not confessed for that committee, stands there.
I may, join in from VC from Delhi on that day.
It would be very difficult for us to, you please, sorry to say, though this is the facility, but it will be very
well,
difficult
brother,
for
I'll
us
be here.
to-
I'll be here, brother. And
Though this is the facility, but in fact, we are facing very difficulty in that.
I'll be here.
Very
I'll be here.
Item 24.
Lordship, in this matter, Lordship, today we have received one affidavit, Lordship. After that, Lordship, I've taken an instruction from my clients.
In fact, my lord, that is the original affidavit that we have filed today. This tender was for a period of 1 year, with effect from June. Now they have already, authorities have already started floating fresh tender. So 3 tenders that we have broken record. That is what we have filed today. So if they want to take a.
Lordship, possibly we'll have to withdraw this appeal because new tenders have come. But without instruction or finding it difficult, let it come day after tomorrow, my lord. In all probability, we're withdrawing.
Day after tomorrow.
Timing item. 14 and 15.
About the Kerala High Court judgment does not cover our case. I'll show that, Milord. What had happened in Kerala case, state of Kerala itself participated in the tender process. I think Lordship is having the Supreme Court order,
We are,
the Kerala matter.
yes,
The Lordship should kindly come to the first page. These petitions arise out of the order dated 19/10/20 passed by the High Court of Kerala at Ernakulam in number of petitions challenging privatization of the Trivandrum International Airport, as well as RFP conditions which are set out in the document inviting participation from private bidders.
yes.
The basic issue highlighted by Sri So-and-so appearing for the state of Kerala is about mutual discussion between state of Kerala and central government with regard to various reservations expressed on behalf of the state government. However, as set out in paragraph 31 and 32 of the judgment under appeal, after all those rounds of discussions, the rounds of discussion, Government of Kerala agreed to the condition that if it could have the right of first refusal in favor of any entity in which the Government of Kerala had 25% of the equity participation in the range of 10%. In terms of such understanding, the state-owned corporation KSIDC participated in the bid unsuccessfully, where a successful party had offered the bid of rupees so and so, so and so. So this was the background, Mela.
No. This was not the background.
No, this was the.
Just now come to Kerala judgment. Do you have a copy of Kerala judgment?
Yeah, I'm holding that Supreme Court order, Mila.
No, sir. What about Kerala judgment? Do you have that Kerala judgment?
Kerala judgment, I think it will, huh? Yes, it will, huh? Yes, Mila.
Now come to page number, para number 2 of the chart.
2.
Yes.
We shall first notice in this writ petition, that's the paragraph, Mila.
Yes.
We shall first notice the writ petitions and the relief spread for in the order in which they were filed. WBC filed by 2 individuals claiming to be frequent flyers and users of so-and-so, seek to protect their fundamental right to travel and assert their private rights. The prayer in the said writ petition is to declare request for issued by so-and-so as ultra vires the provisions and to forbear from entrusting TIA to any private entity, though the writ petition was filed first in time and an interim order was declined by the learned single judge. The further proceedings were not challenged, nor was the successful bidder implemented. Next writ petition filed WPC by Union of Employees of Calicut Airport, which challenged cabinet approval for leasing out 6 airports dated so and so.
That is somewhat different.
Hmm.
This year, 2224/2019.
Yes, Miller.
This writ petition was disposed of, in which the claims which you have raised in this petition are similar to that.
Well, our case is slightly.
And the learned single judge, after taking into consideration the all facts and circumstances of sorry, not learned single judge, the Kerala High Court division bench, after taking into consideration all these facts and circumstances, has this page 95.
Yes, Miller.
After considering all the whatever the contentions, they have said writ petition number 2224.
1 second.
Oblique 2019, which was filed.
Yes.
in public interest by some persons, they have dismissed that petition also.
WPC and so-and-so filed without establishing their locus standi.
It's same.
We find them to be mischievous and an abuse of the process of this court. And we would have, while rejecting them, imposed heavy costs, but for the fact they have not taken any additional time of this court. Hence, well, ours is not a case of lack of locus standi, my lord.
Sir, public interest?
Hmm?
Public interest?
No, my lord. Our case,
You have
no, our case is structured on a totally different basis, my lord.
You just go through this judgment. They have dealt with in extensive everything which you have argued in your petition in this
But
Kerala.
my lord, going by the Supreme Court's order, what we find is, my lord, what was dealt with by the Honorable Supreme Court was the appeal of the state of Kerala.
But sir, this order, whatever it may be, this order has attained finality if they have not challenged that order.
No, my lord, these are all, this is a Kerala High Court matter. Lordship will decide our case in his own right. My lord, I'll show your lordships 2-3 points, my lord, and I'm also relying on one Supreme Court judgment.
Sir, you just please go through this.
Okay, I'll go through it.
And in this, whatever objections you have raised, and this petition has been possibly taken.
I'll go through it, my lord. Lordship will call it after.
And then what?
Okay.
That has also been rejected?
No. No, he says same judgment, it is reported.
There are other writ petitions decided.
Other writ petitions?
But along with them, Lord, this judgment, Lord, there are several other issues which have also been numbered.
But here in this, I think for 5-4 petitions, they have decided.
But the issue that has been raised in this petition, that those issues have also been dealt with.
No, section 12 aspect has not.
Everything is there. You just go through
Anyway,
it.
I'll go through it.
Go through it and
Possibly. But initially, Lord, these petitions were dismissed because of the dispute under Article 151. Lord. That went into for apex court, Lord. The apex court set aside that, Lord, again remanded the matter for deciding afresh. Then all the issues were taken together, Lord, and finally the judgment has come.
that the judgment which you have supplied, where is there? Which is that judgment?
The same judgment, Lord. But I have reported.
You have given the copy to Mr. Chaudhary, na?
Yes, I have.
I'll go through that.
Hello.
Here two batch of petitions, one by in public interest and another by employees.
Yes.
I'm pressing the, my lord, the public PL.
We then go ahead.
Yes,
I'm appearing for the other matter, madam.
Possibly both these matters are covered by this.
I will-
Whenever you go through it, it is covered. We are.
My lord, we would like to urge only one point for your lordship's kind consideration is, my lord. Now, what can be leased out? That's the very crucial in this case. My lord, will rely upon section 12 and 12A of the Act, read with section 28. What we are saying is, my lord, the airside thing, it cannot be, my lord, leased out. That's the finding of the Parliamentary Standing Committee also.
Yes, we'll go through it.
I have two sets of judgment, one from Kerala High Court and other from Karnataka.
Fine.
But I'm happy to go for it.
I thought it was like Kerala.
It will be like next power cutting moment.
And in fact, my lord, we'll be relying upon that Bharat Petroleum case where Supreme Court interfered. Oh, yeah.
We'll consider.
Yes. In fact, my lord, BPCL was sought to be privatized. Supreme Court intervened. That's the judgment reported in 2003, 7 SCC 532.
Okay, we'll consider. When is it?
After 2 weeks, my lord.
June.
Deeply obliged.
Deeply.